Happy Thursday. It's time for Coffee and Cursey Words, and Emily has tech issues because why wouldn't we? It's so good to see you. Today, do I have my notes up? No, because I've restarted everything multiple times. We are going to be talking about Erika Girardi's earrings because there are some legal documents that we have not gone over yet that are full of my favorite, well, one of my favorite things. One of my favorite things, emails. So we're going to be going through those legal documents that have emails. We are going to go through a number of quick bit stories, and we have so much to talk about. And then I know there's questions from yesterday's podcast episode covering the Balenciaga scandal, the Supreme Court case that was in the photo with the Adidas collab purse, and all of it. So we are going to do that. I'm going to leave time for questions. And then I have a hard stop today because I have some things to record that may be coming to your TV later this month. I will let you know when I know more about air dates. For that, I'm gonna have to zhuzh the hair a little bit. We got fresh color yesterday, so we are ready. But I've got things to do, and I didn't want to cancel our stream. I'm like, no, I'm not canceling our stream. We're gonna have to just do it later. So we have a lot to do today. I have a lot to pull up. Because we're not. We were ready, and then we weren't when I restarted everything. When I close out my computer at the end of the day for a stream in the morning, I know that mornings are rough. I am ADHD. I always run behind. I always think I can get more done in the time that I have than I can. And so I leave my notes up. I leave my StreamYard up. I leave all those screens up so that in the morning when I sit down at my computer pie. When I sit down at my computer, good, today's going to be good. When I sit down at my computer, I'm just ready to go because I want it to be frictionless. And today it was going to be until it wasn't. And that's just all right, because you know what? We talk about the things, you guys know, it's always, I feel so bad when I am late because I know there are people in the chat who haven't been in the chat before, or who this is the first time coming in because of their topic. And they're like, girl. And I'm like, I know, I'm sorry. I'm sorry I'm here. So let us go. Replay crew, love you. The timestamps will be down below, and we will do all of the things. So BC asked a question. I'm going to get to this after I see it. I'm going to get to it right after the intro. So I'm going to roll the intro. I'm going to pull up my notes for today. I really want to go through these court documents. Look, I needed some lower brain energy stuff today just because it's going to be a busy day. I have a lot of stories to cover in an interview later today. And just to be perfectly transparent and upfront with all of you, when I know that I have a mentally long day, I really do need to plan. Look, the mental energy it takes to do things and to do them well varies by person, but the neurodivergent spicy brain sometimes will not give us what we need late in the day if we have exhausted it. So I needed to pick a stream today where we could cover some things that were not as taxing to regulate. So we are going to talk about things, well, in our main topic, that are not as taxing for me to regulate. And that is something that I'm still learning about myself, but I'm happy to share it with all of you because I don't want you to feel like, why can't I get it all done? Why can't I get it all done in the day? Sometimes you just can't. And so I am now getting much better at not holding myself as like a failure for that, but planning myself better so that I can set myself up for success, and making sure that I am planning my day so that I can set myself up for success. And I'm trying to teach my children that too, though the world is not always set up for us to choose our own adventure. My kiddo has some of his most difficult classes in high school earlier in the morning, and some of the classes that are a bit easier for him later in the day. And it is such a blessing. I wish that he could pick that all the time. And I'm trying to help him figure out when his brain works best, and the energy it takes to be like, okay, this is a high energy brain task. This is a lower energy brain task. So the lower energy brain task is going to go later in the day. And I know those of you that deal with this either mentally or physically or both, know exactly what I'm talking about when you have to plan your day around your own capabilities. And we talk about it in, neurodivergent communities. We talk about it in disability communities. We talk about it, but I think everyone should be talking about it because all of us have our own quirks, and all of us push ourselves, and then think that we're failures because we have not pushed hard enough, or that we can't push as hard as somebody else can. And it's really, that's all just a bunch of bullshit. We're all different. We all have different ways of working. And I hope as we start to understand each other better and connect with each other better, that we're able to build our world a little bit better so we can say, hey, I can't do that meeting at 4 o'clock. I won't be my best. And that it's normal to just say, can we do it at this time? That is a better time. And having this conversation and really being comfortable saying, that won't work for me. And you don't even need to offer an explanation. That won't work for me. Can we do it at this time? Or I can't do it then. Can we do it now? And not needing to explain ourselves, not needing to apologize, and just setting those boundaries so that we can work in the way that works best for us. And it's something that we all need, not just those of us who have been forced to discover this about ourselves because we literally can't anymore, but it's something we all need because all of us have times that we're better. All of us have times that we're overwhelmed, and you can't be your best all day, every day. I mean, athletes know this very well, that you can't be your best all day, every day. You need recovery time, but we treat the physical recovery different than we treat emotional and mental recovery. When you have a huge report to do, or a huge paper in school to do, or a huge presentation, we don't give ourselves the time to recover from that outpouring of energy and focus and attention. But if you ran a marathon, you'd give yourself time to recover, wouldn't you? So I just hope that we can all start treating it the same. Like, I've had this massive outpouring of mental or emotional energy or upset, and I need time to recover the same way you need time to recover from physical activity. And it has taken me a long time in life to learn this, which is why I'm sharing it with all of you, because I hope that if you're hearing it going, oh, that's not just me. No, it's not you. Or, oh, it's not just that I'm not capable. No, no one is. We're human. And anyone saying, oh, you can just work at your best capacity for 12 hours a day, they're lying. You can't, because your brain will downregulate certain parts of the day because you can't. We just don't talk about it. We just don't talk about it. So when we deal with things that are highly emotional, when we deal with things that are highly intellectual or cerebral, when we deal with things that are exhausting, we need to treat exhaustion the same. And we need to treat emotional exhaustion like we treat physical exhaustion and give ourselves time to recover. And that can be secondary exhaustion too. That can be a trauma in your life, but that can also be dealing with really heavy things going on at work, really heavy things in the news. Sometimes we just need a minute to breathe and say, I need a little recovery time. It could be spending a lot of time with family. Even when you love your family, it can still be a lot. So everyone, all of you, I know I talk about my spicy brain. It's the thing I'm most intimately familiar with, but all of us need a little bit of grace, and all of us need to give ourselves grace. And let's just normalize setting boundaries and saying that doesn't work for me right now. So today was that I can't dive into another heavy topic today because I have so much to do this afternoon. And so today we're doing some lighter topics. We have a poll going. I'm going to give you guys a preview of the final poll. One of my friends is getting towards the end of her time as a district attorney. So every time she's called, I've been singing the final countdown to her. Like, I answer the phone singing the final countdown. And that's where we're at with our new food segment that will be rolling out on Tuesday with a name, because we're doing polls. So we're doing polls over on the YouTube. I'm very excited. So we're going to talk about what our options are there and give you guys a preview for what the final countdown is. The polls are going to be on your community tab. So if you go to my channel, you'll see it on the community tab. There is one poll still rocking. We're going to talk about what the final four is. We're going to talk about the topics that I laid forth today. We're going to read people's emails. My favorite. And we're gonna leave a lot of time for questions because I talked so much on Tuesday, we didn't have a ton of time for questions. So with that, I'm gonna roll the intro. We're gonna pull this stuff up. Don't forget to like and subscribe. I always forget to ask. I'm like, oh, I forgot to ask. And I need to remember to ask because YouTube's spicy about the Balenciaga videos. So YouTube's like, this is not a topic that we want being discussed. And I get it because once you're talking about Balenciaga, YouTube is correlating it to the underlying thing. And the underlying thing is not super platform friendly. This is not shade to YouTube. It's just understanding how the game works. Because when YouTube looks at a topic that is not advertiser friendly, it's not what they're pushing out. Why? Well, they're not going to make nearly as much money. Especially if I have monetization turned off because I don't even want to deal with it. Which is why I have all of you and our lovely channel sponsors and the Law Nerd Shop and our members. It allows us to say this topic's important. Who cares if YouTube likes it or not? We'll put it on a podcast and we'll put it on a podcast episode and we'll still talk about it. Let's roll our intro. Our intro is getting a makeover for the new year. I'm very excited. The music's going to stay the same. I commissioned this music for the podcast, but it's gonna get a little bit of a spicy makeover. It needs it. It's time. We're gonna kind of refresh it each year. It feels good. It's like it's a seasonal refresh. And at some point I have to update how many years I've been a lawyer because this intro's been rolling for a few years and there's more of them now. Time marches on. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. Do I love our intro? Yes. Did I realize just now as I was pulling up, because my morning has started like I was shot out of a cannon, that today is December 1st and I'm having like emotions about that? Yes. I can't believe it's December. I cannot believe it's December. I am absolutely blown away. But here we are. Here we are. Did I see, I've been getting asked this a lot. Did I see that Judge Darrow, thank you, Marissa. Did I see that Judge Darrow announced she's running for Wisconsin Supreme Court? Yes. It's interesting to me that it's an elected position and not an appointed position. So it's interesting to me. Aussie, just over 3 weeks till Christmas Day. Well, when you put it like that, the time is marching quickly for me. So I'm going to get to a few of our super chats before we get all the way into the topics, and then we're going to get into quick bits. Stephen asked, and this is a great question, Stephen, thank you. Are you mentally and emotionally healed up from the Brooks trial? I thought I was. But my kids have Christmas parades that they are in this weekend, and I had a moment. I was like, okay, I'm not. And I've gotten messages from a number of you that are like, it started being Christmas parade season. And I realized in the car on the way or while I was sitting there that I was either emotional, upset, overwhelmed, just it lingers with you. So yes and no. I'm a little on guard about their Christmas parades. I have some different emotions. I have some different emotions about the Christmas parades this year than I did last year. Charlotte, happy birthday tomorrow. So with that, it sticks with you a little bit. So yes and no. CK said, and now he's appealing, as one does. I mean, the appeal's not going to go anywhere, but it is I don't know. It's, for me, it's not something that I have a lot of emotions about because it's so part of the process. There's a thing that happens, there's a trial about the thing that happens, and then there's an appeal about the thing that happens, and then there's a final thing. And so I'm used to expecting there to be an appeal and a final thing. I don't see an appeal as, I don't know, I don't see it as disrespectful. I don't see it as like, "Ugh, what are they thinking?" Sometimes in civil I do go, oh, what are they thinking? But in criminal, it's literally part of the trial process that is going to happen. Um, K-Rab in the chat said, just realized it's my birthday today. Me. And I just hit 60. A huge Lawnard happy birthday to you on your birthday today, K-Rab. I mean, that, me. It's like, wait, shit, it's December 1st. Yes. Yes, it is. All right, let us keep going. Your hair retouch is fire, going for mine later today. Thank you, Dawn. Homesick from work, stomach bug, but at least I got EDB. Here we go. We're here to keep you company. We are the Lawtubers. We are the YouTubers. We are here for you. Hey from Canada, love your channel and community. Thank you, Sarah. I do too. So good. Jen Gerard, good to see you, friend. Thank you. I'm wearing my Gerard Cosmetics. I'm wearing much more makeup today because we have to do things later. I'm like halfway done. It's always weird. There's still like fake eyelashes and stuff. The hair has to be zhuzhed a little, but yes, it's a lot. Jessica said, dealing with company layoffs today. I'm so sorry. Well, I'm good. Still feeling feels, of course. And the layoffs are so common this time of year, and they always feel so awful this time of year. Recommend reading Laziness Does Not Exist to help with productivity overload. Jessica, I love that recommendation. Thank you. And I am sorry. It is very overwhelming. Even when you're not the one losing your job, it is still overwhelming. Texas Caddy said, my poor sister hated teachers comparing her to me. My mom had 2 neurodivergent, high IQ kids. She was the quote unquote normal one. She was never in trouble like us. It's hard. My brother got that a lot. My brother is, I don't think my brother's neurospicy at all, but my brother got a lot of, oh my God, it's so much easier than your sister. And he's like, well, all right. I am much spicier. My brother keeps the spice on the inside. He's much quieter about his spiciness. Bex said, thank you for recommending Melissa's Book of Boundaries a while back. I just started reading it and can tell it's going to be a game changer for me. Bex, you are welcome. So many of us were raised, the best our parents could do, but not always with boundaries. And I think my parents' generation, boundaries were not something they were allowed to have, that they were expected to act a certain way and they were not allowed to set their own boundaries and what worked for them. So, it's interesting when you're raised by parents who were not really allowed to have their own boundaries. Some fight through that in different ways. And so trying to find your own and then trying to parent your kids to have their own boundaries, which is challenging in and of itself. When your kid sets a boundary and you're like, right now is not the time for a boundary that you're not going to wear shoes because it's actually snowing. So I appreciate that you want this to be the boundary. However, I need your feet not to freeze because it is my job to keep you safe. So it's really interesting. So the Book of Boundaries is fantastic. If you don't follow Melissa Urban on Instagram, I don't know if she's on TikTok. First, her hair is always glorious. We love this. Hair is always on point, but she does a lot of modeling on how to set boundaries and how to talk through those boundaries. And it's just so great. It's just so great. And I appreciate it because sometimes I need the words. So Kesto said, women in my mom's generation were not allowed to have boundaries. And, it's something that there's times I'm frustrated. I'm like, Mom, you can say no, like it's fine. But I realized for her, she didn't always get to pick that and it wasn't acceptable for her to do that. So I've just leaned into forgiveness and now say, Mom, you can say no. My feelings aren't going to be hurt. So you can say no. Or you can say yes, or you can say, I don't want to do it that way. It's fine. Just tell me what you want. I'm not going to be mad. But it's hard. So I love the Book of Boundaries. I have it on audiobook. I love following Melissa on social media. She had a whole thing on modeling behavior with the holidays. And a lot of the things she talks about are around food, but the boundaries are the boundaries, whether it's around somebody not heaping crap you don't want on your plate, or whether it's about just saying, hey, that doesn't work for me right now. So she does have TikTok. I'm not surprised. So anyway, Will and Admin, please link the book. Oh, you know what? Heather, you asked a great question. Hold on. Let me see. And then I promise we'll get into topics. Let me see if I put it in my Amazon shop. I should have, because then it's real easy. So let me take a look and make sure it's there. Let's see. Under books I love. If I need to go, nope. We're going to go at it right now. I have a books I love section on my Amazon shop, and Nightbot shares the Amazon shop, and then it's always in my descriptions. So let me just add that real quick, because I because I forget to do things. So we're gonna go do that right this moment, and then we'll be back to our regularly scheduled program. But it is called Book of Boundaries. Um, and I really love the way Melissa engages with her community too. And I love the conversations, like even looking in the conversations on her comment section, I find to be so incredible. So I really love it. Why this is only showing, it's like, do you want the audio one? I'm like, no, I just want to put this so people can find it. But yes, I want the audio one. I always want the audio one. All right, we're linking this right now to my shop, and I will show you where that is if you haven't been there. So it's just, where is it? There it is. Ha! Unable to add item to list. Why? Why are you unable to add the item to the list? That's not helpful. Amazon, do better. What is happening? Give me 1 second and let me see if I can. I don't know why that's not adding. All right. I don't know why that's not adding. I find that really frustrating, but it is this book on Amazon. Y'all can go, oh, let me share screen. And I will fix it after the stream when I can sit down and noodle with why it's not working. But it is by Melissa Urban. I will also just put a link in the chat. It's by Melissa Urban. It is this beautiful book of boundaries. And I will plunk a link down into the chat. And then I will figure out why it's not working. Because, because why would it? Because why would it? Because today is today. And why would it? Because today is today. But I do have an Amazon shop, Emily D. Baker, or amazon.com/shop/Emily D. Baker, and that is linked by Nightbot. So, yes. Rebecca said, I am forever having to tell people who schedule Zoom meetings in the evening that they will not get my full shine. Or wait, what does that say? That they will get my full shine, but not expect me to be quiet or easily controlled. It's fair. It's very fair. And just, I think knowing ourselves is something that we don't really talk about. So yeah, we don't talk about knowing ourselves. We are taught a lot to conform to what other people think is the way to do it. I don't like to conform to the way. This is the way. It's like, says who that this is the way? There are some things that are universal truth, like, coffee is amazing. But even that, is it really a universal truth? It's just my universal truth. All right, let us continue. BC said, can YouTubers be held in contempt of court for hot mic and live streaming the LESAC AWP hearing in Utah yesterday, causing the judge to cancel the hearing? It is on the record which channels did this. I have not seen this, but I would like to take a moment to talk about streaming court hearings because, that's not what I wanted to do, because it's important to take a moment to discuss. Here's the thing. Most court hearings are publicly available. However, to record or redistribute, and sometimes even live tweet, you, in almost every jurisdiction, need express permission from the court to do so. That said, court proceedings that are using pool cameras, like the Darrell Brooks case, there was one camera in court provided by Court TV. I think Court TV did an excellent job. I really do think Court TV does a great job of providing cameras in court. Where Court TV loses viewers is they take commercial breaks because they're mostly streaming on traditional television, not on the internet. So they take traditional breaks, so they lose their YouTube audience because there's just a break with a blank screen. But they do a great job of placing cameras in the courtroom. I like most of their commentators. I say most because I'm sure there's someone I haven't seen, and I don't want to say all because lawyer, that's too broad. But Chanley Painter is on site all over the place, keeping us in the loop, which is absolutely incredible and a job I don't think I could ever do. But they did a great job with the Brooks trial, a great job keeping the cameras off of, minors who were speaking during the victim impact statements and not showing the things that the court said couldn't be shown, and really working with the court to show what could be shown publicly and not show some of what can't be shown publicly. When there are streams like that, that camera is a pool camera. One camera and the feeds go out. And the feeds go out, and Law and Crime uses them. I use them. Other streamers use them. The news media uses them. All the different news channels take those streams and stream them. The court has given permission for those things to be streamed. And those pool cameras are not the copyright propriety of just the one person. They are shared. So no one really owns the stream. It is a public stream. So those are different. A court hearing that is a Zoom call that the public can attend, like when I attended the hearings in Illinois for the Girardi contempt hearings with regard to Lion Air. Those contempt hearings were streamed and open to the public, but those were not available to be restreamed. You can't get on a Zoom call. I mean, physically the technology exists, but without the permission of the court, you cannot take that broadcast, get into the stream or into the Zoom, and then restream that Zoom. It is not allowed by the court. Now, will people try to push that and say, well, what's a court in Illinois going to do to me? Yes, people will try to push that. Here's where the pushback is. The pushback is then courts will be more hesitant to make things available using technology. We saw it happen in the Britney Spears case. Britney Spears had one hearing that was open for the audio attendance program. I forget what it was called, but the audio attendance program. And with the audio attendance program, then you had somebody restreaming the feed. The court found out about it. The entire fucking county of Los Angeles shut down the program, so you can't remotely access. That's what it was, the remote access program. You can't remotely access any court hearings in Los Angeles anymore. And courts will do that. Courts will say, okay, fine, come then. Come then. This is a public hearing, the doors are open, walk into court. But it restricts transparency. So if people take Zoom court that is not already given permission to stream, you can ask the court for permission. We see it in the Britney case every time there's a hearing. You see all the filings of like permission to stream, and then you see the court going denied, 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 denied. So you can't stream it, but you can ask permission to stream. Sometimes you can ask permission to attend hearings that are remotely available, but not remotely available to the public. Courts will stop making these things available to the public if the public fucks around. They will find out, and the court will say, fine, there's no Zoom hearings. Or the court will do it where you have to request permission and be approved ahead of time and have to prove that you are media, which is going to make it harder for media that is non-traditional media, depending on how the courts define media, because each court defines media differently. And some courts define media as you have an editorial board, so you have multiple people that your stories run through, which most streamers do not have. Some do, most don't. So streaming something is a huge problem when you don't have court permission. For me, if people want to push the envelope, whatever, but it is the duty and the obligation of the person that goes in to a hearing to know the rules of that hearing. And in almost every jurisdiction, the rules are you need permission of the court to stream. And you can find the rules on the website of the court. So that's the streaming component. Having a hot mic issue on a Zoom is different because it's generally not intentional. So a hot mic moment is generally not intentional. And the thing is, though, courts have a little control on being able to shut that down. But as an attorney, when I was attending court calls every single day, because I did a lot of court call work, when I was attending court calls every single day, I would literally be sitting there staring at my phone to make sure that it didn't somehow unmute, to have plug-in headphones, to be in a quiet environment because there are so many rules. And if you are the attorney showing up in court call and you're the one with a hot mic, you're the one who's going to get chewed out, and the judge can actually take action against you. So it's different. So if there is a hot mic that's accidental, courts have no tolerance for it because most of the people attending court hearings are lawyers, and they absolutely do what they can do to make sure that that doesn't happen. Do lawyers have gaffes in court? Yes, we saw lawyer cat. Some judges are more kind. Judges dealing with technology and public interest for the first time in a hearing might be less so, especially if it interrupts proceedings, and then might say, we're not doing this again. We're not doing this again. But the court can also mute everybody coming in. But these are courts having to learn technology. Look, half of my job as a different district attorney, maybe more than half, was helping other attorneys figure out how to use their email because they had never done it before. And this was in the 2000s. And a lot of my job was, did you turn it back off and on? Have you opened the email program? Do you know which program the email program is? Courts are notoriously bad with tech. Some are better than others, but courts are notoriously bad with tech. So there are two different things. The streaming is an issue that shouldn't happen and is going to ruin it for everybody. Hot mics, if it happens in a court hearing once, the court's going to be pissed. If it happens more than once, the court's going to lose their mind. So if you ever want to attend court hearings, if they are public hearings, you're allowed to attend. My recommendation is to use a wired headphone to make sure you are coming in from a device that isn't going to accidentally mute and unmute through a headphone or through bumping a phone or something, and to make sure that you are prepared and to treat it seriously so that you are, if you're on Zoom, you are adhering to the rules of the court, which generally include no fucking screenshots ever, not ever, not no screenshots. Also, courts will say no live tweeting. And so there are times where if you are attending a Zoom and you are live tweeting out what's happening on it, that the courts will have an issue with that. There are some courts that if you are attending a Zoom and listening to it in one ear and talking about it on the internet in another one, the courts might have issue with that. I am personally a better safe than sorry kind of a girl. So if I will look at the court rules, I will look at what the court says on their website, and if the judge doesn't say no live tweeting, I am comfortable live tweeting it or live blogging it, but I will not listen to it and stream it at the same time if the court says you can't redistribute it. You can't record those for later. Do people do that? Yes. Does that violate court rules? Yes. So hopefully that helps break down all of that. So hopefully that helps. Hopefully that helps. And that's where it is. So Emily in the chat says AirPods connecting and disconnecting is a gamble daily. Yes. I used corded headphones for all of my Zoom court. So how can Law Talk with Mike rebroadcast Zoom court proceedings? If they are Zoom court proceedings that are already posted in the internet, there are courts that stream their Zoom court. So there are plenty of courts that stream their Zoom court. Those are already publicly available. I imagine Law Talk with Mike isn't streaming anything that can't be streamed and isn't streaming anything that's not available, or is asking permission from the court and receiving permission from the court. So, you can do that. Courts can grant permission. It's fine. I'm giving you the general is a no, and then you have to ask permission to get to yes, which isn't that most things in life. Assume we're at a no and then ask. assume we don't have consent and go from there. So with that, we will go through it. So that. And I trust lawyers to know the rules. It's literally your job to know the rules. And the thing you learn most as a lawyer is how to research and figure it out. And I trust people to research and figure it out. When it comes to those who don't regularly deal with the courts, I have absolutely a little bit more understanding and compassion, but you have to, when you're going into court, be mindful and make sure your technology does not screw it up. So It's hard when there's a lot of public interest. People want to be the first of the story, and they're like, the court won't know. Um, the court will know and will shut down hearings, and it sounds like that's what happened. I'll look into it a little bit more, but that's kind of my general of tech blips happen, but it can really piss off a court. Judges aren't always super patient. Remember, often they're hungry. So just know that you're dealing with someone who's hungry. And then the streaming is a whole different thing. So it's all BS. Thank you for gifting memberships. Much, much appreciated. Um, Bobby said what happened was Dusty Ron, I don't know who this person is, accidentally unmuted his mic during a recess. He wasn't live streaming it. He was listening and relaying the information back. Only one YouTube creator claimed to have permission. If someone had permission, that's fine. Sometimes court rules can be very picky with listening and relaying back in real time. Sometimes not. It depends on the rules of that particular court and the way they word what is allowed and not allowed. Some courts allow no live tweeting and allow no contemporaneous kind of broadcasting of what's happening in court. If a court allows a live tweet, I don't see how listening and talking it out is much different than a live tweet if you're not repeating it verbatim and you're not streaming the audio. It just depends. But people need to absolutely make those decisions for themselves. So the question was, can they be held in contempt of court? It's difficult, but if somebody violates the court order that they're subject to, then yes. But it's difficult. Let's see. You are welcome for keeping you company. Miss Opinion, are we getting court of public opinion back? Yes, we are getting court of public opinion back. Where we are getting it back, I have not decided. But yes, we are getting court of public opinion back. Okay, we need to get to quick bits. What do we talk about first, y'all? Do you guys care about the Kardashian divorce? Do we care? Do we care at all? Do we care about the Kardashian divorce? Or do we just want to get into the TikTok lawsuit, Meta getting fined hundreds of millions of dollars, and the Masterson mistrial? Do we care? Do we just not with the Kardashians today? Let's put up a poll. Miguelina, Kim K divorce, yes or no? And we might just skip it. Let's talk about the Masterson. Let's talk about the Masterson mistrial first. We'll put up a poll. If we're just over it, then we're over it, and I won't talk about it because I think we're all feeling a little overexposed. All right, let's get to quick bits. Quick bits. Emily, there was literally nothing quick about you talking about Zoom court. Correct. Correct. There was literally nothing quick about me talking about Zoom court. All right, the Masterson mistrial. Let's talk about it. All of you, well, some of you may or may not know. Let's do a quick road so far. Danny Masterson, who had been on that 70s show and other things, was in a 3-week trial with 4 victims who accused him of horrendous acts of SA. The jury before Thanksgiving break was indicating that they were deadlocked. The jury came back on Monday, and then on Tuesday, the court declared a mistrial, finding that the jury was hopelessly deadlocked. Look, there are quite a lot of rumors going on around the internet about whether the Church of Scientology played any role in paying off jurors, intimidating jurors, anything like that. I'm not going to speculate. If anything like that comes to light, I trust that the district attorney's office and this district attorney, Reinhold Mueller, will take that to the appropriate law enforcement and will take that very seriously. I trust that that will happen. So if that is the case, I trust it will come to light and hope that it will come to light. With that, we're going to talk about this split because this split is not one juror holding out, and that is a big consideration. So I think we need to talk about this case and the split of these jurors before we talk about was one juror or two jurors impacted, because that really is just conspiracy speculation, to steal a word from Peter Mon, that we don't have proof for. Would it shock me if someone tried to manipulate a jury? No, I would not be shocked. Do we have evidence and facts proving that? No. And this jury was split towards not guilty, in a big split towards not guilty. I have had a number of hung juries in my time. I have had the most experience with one juror that was holding out. One. So in those splits, I had a case with one juror who should have been kicked, but the judge was and I knew it was going to hang 11-1. It was on a third time DUI. I was pissed. I had another one where this juror was just obstinate. The judge probably should have replaced the juror with an alternate, but the jurors didn't tell us. The jurors didn't say this juror is refusing to deliberate. It was a juror refusing to deliberate. They hung 11-1. That juror at the end, you could see it as they were walking out of the room. That juror walked off and the other jurors stayed in the hallway and wanted to talk truly about that one juror. And I'm like, things I wish you would have told me. That juror refused to deliberate. We have alternates. And the alternates very much would have helped with that. And we could have gotten rid of that juror to someone who would deliberate. I don't think they knew and they didn't ask. And the judge probably should have asked, and I probably should have asked, and I didn't. So again, you learn things in a long career where you're like, I would have done that. I would do that differently now. This judge did, and this is a long-standing judge who's very well respected. This judge sent the jury away for Thanksgiving, brought them back, and they tried for 2 more days to reach a verdict and didn't. So with that, let's take a look at this split and let's talk about what it means. Oh, I have the wrong screen being shared because I moved things around. You don't need my notes. Let's change it. Let's change that. So this jury is split and we need to talk about it. So thank you for let's talk about the facts and what we see here. This is coming from the Associated Press. Mistrial after jury deadlock and Danny Masterson. Words that we should be able to say on YouTube and can't say on YouTube. I'm going to say essay. Y'all know what it is. Los Angeles, a judge declared a mistrial Wednesday at the essay trial of that 70s show actor Danny Masterson after jurors who were leaning strongly toward acquitting him deadlocked following the month-long trial in which the Church of Scientology played a supporting role. I don't know why they worded it that way. I don't know if the Church of Scientology, what do you mean by supporting role? This is the thing that's difficult for me. The church played a supporting role. How? The church factored into this. And the church factored into this because this is a case of delayed reporting. And the reason the reporting was delayed is because the alleged victims in this case went forward and told people, and they were told, you can't tell anyone. So the reason Scientology came up is because it explains why there is a gap between reporting. So, I don't know what they mean by supporting role. It's an odd use of words for me. It's just an odd use of words for me. Prosecutors said that Masterson R-worded 3 women. God, I hate being a YouTuber like that. Things I should talk about on the podcast where I can say words. Including a former girlfriend in his Hollywood Hills home between 2001 and 2003. And that the church dissuaded them from going public for years. Masterson, 46, pleaded not guilty, and his lawyer said the acts were consensual. I find the jurors hopelessly deadlocked. Judge Olmedo declared after the jury foreman said that there was nothing a court could do to move them closer to reaching a unanimous decision. She set a March date for retrial in the Los Angeles Superior Court. Here's the thing. A March date for retrial does not mean that a retrial will happen in March. I'll talk about that in a minute. That doesn't mean it's 100% happening. That's the next court date, because the only thing to do next is a trial. The district attorneys can come in on that date and say, we're not retrying this case. They have not decided whether or not they will retry this case, and that's going to be a longer decision. I'll talk about that decision in a minute, or how those decisions are made. I don't know anything about this particular decision. I'll talk about how those decisions are made in a minute. But the fact that there's a date for a retrial doesn't mean a retrial is happening. I just want to be really clear on that, because I saw people saying, oh, there's a retrial in March. That decision has not been made yet and might not be. The judge ordered the jurors to take Thanksgiving week off and keep deliberating after they said on November 18th that they could not reach a consensus. The jury of 6 women and 6 men began deliberations anew on Monday after alternates replaced 2 jurors who were diagnosed with the vid over the break. So they already had alternates come in. Jurors voted 7 times Tuesday and Wednesday. That's a lot of votes, without being able to reach a consensus on any of the 3 counts, the foreman said. Did I say 4 earlier? I might have said 4 counts earlier. 2 jurors voted for conviction on the first count. 4 voted for conviction on the second count. 5 voted for conviction on the third count. Those are splits showing that this jury was inclined to acquit Danny Masterson, not convict Danny Masterson. This is a jury leaning heavily towards acquittal. I will say there is a case that I felt very strongly about that I retried. I was not lead counsel in the case, but we retried it. The hang was leaning towards acquittal, and we very deeply believed in our case, and we prosecuted it again to a conviction. But there are very many times when you're looking at the evidence that you presented to the jury and you look at your case and you're like, can we present this differently? Where was this jury? And if the jury talks to you, you might know where the jury was hung up or where they had issues or where they did not believe what was being told to them. And you then decide, after talking to all of the alleged victims in this case, you talk to them about what it's like to go through a retrial, and I can talk about that in a minute. Let's finish with this article first. The result is a serious setback for prosecutors. Yes. And for the 3 women who said they were seeking long overdue justice and provided emotional and graphic testimony over several days. Yes. Because if it's retried, they have to do it again. Danielle's asking, what are the cons of retrying a case? I'm going to answer that after we get through this article, because it's the number one thing we need to talk about. I see some great questions in the chat. I'm going to try to grab those as I'm reading this, because you guys law nerds are the smartest community on the internet. I'm just saying. Y'all are bae. All right, let's keep going. 2 of the alleged victims in this case issued a statement saying that they were disappointed Masterson had evaded criminal accountability for his deplorable acts. However, they are collectively resolved to continue our fight for justice. I think that's a very conscientious statement. You know what they didn't do in this statement? Not once, even though they must be gutted. They didn't blame the jury. They sure didn't. That's a very, very strong statement. We're disappointed. And we will continue to fight for justice, which indicates to me that the 3 accusers in this case would be okay with a retrial when they talk to the DA, because that's what a continued fight for justice might entail. But that is a very respectful and powerful statement. It's a respectful and powerful statement. All 3 women were members of the church at one time, or at the time, M. Masterson remains one. 2 of the women and the husband of one are suing Masterson, the church and its leader, and others for allegedly stalking, harassing, and intimidating them after they sought to expose Masterson. I need to go pull that civil case. I need to make a note. I'm interested in what their civil case is. They might have better luck in the civil system where jurors don't have to be unanimous. Masterson left court with his wife, actor and model Bijou Phillips, without speaking to reporters. That's appropriate. He was accompanied to court many days by members of his showbiz family, as well as his sisters-in-law, actor Mackenzie Phillips, and singer and actress China Phillips, and her husband, actor William Baldwin. The 2, which is interesting too for a jury to see that. The proceedings took place amid a flurry of cases on both coasts, which with Me Too connotations, including the Los Angeles trial of Harvey Weinstein, which was just down the hall from the Masterson trial over on the 9th floor there of CCB. In New York, the Kevin Spacey sexual misconduct lawsuit that he won. That was a civil trial. The other 2 are criminal. But the Masterson trial, as at the Haggis trial, #MeToo implications were largely eclipsed by the specter of Scientology, despite the judge's insistence that the church not become a de facto defendant, which is appropriate. Deputy District Attorney Reinhold Mueller said the church had tried to silence the women, and that was the reason it took 2 decades for the case to go to trial. And that's also appropriate. You have to explain to the jury. You have to explain to the jury why. Because jurors want to know, okay, well, if this happened and you're saying this wasn't consensual, why did it take so long to go to trial? Because the defense will argue, look, they decided this was not consensual later. That's what we saw argued in the Weinstein case in their opening. Look, they decided later. It doesn't change that this was consensual at the time. So that's the argument they'll make. So the DAs have to say, no, they knew the day this happened that this was not okay. And the reason that it took so long for them to report it to law enforcement is because of all of this. It needs to be explained to the jury, and I think it's appropriate to do so. Church spokesperson Karen, I can't pronounce Karen's last name, Powell, said Mueller had misrepresented church doctrine and beliefs and that the Jane Does made false allegations about Scientology. Powell said there is zero truth to any of the testimony that the church has harassed or stalked the Jane Does. Cohen said he would file a motion to dismiss the case based on the way the jury voted. He said jurors provided additional insights after the mistrial ruling that were helpful, but wouldn't discuss what they told him. We're going to talk about that in a minute. I wonder if they also spoke to the DA. If the jurors only spoke to the defense attorney, the DA is going to have a very long conversation with all of the bosses, of which there are lots, about how this jury felt about the case. If the jurors talk to the DA, it can also be very insightful. But I'm not surprised the defense attorney is not going to say what the jurors said. And I think that's appropriate too, even though I want to know. The defense attorney said, you always wonder as a lawyer if what you're doing in court every day is making any inroads with the jury. Clearly, we made inroads. Yeah. The defense case was better taken than the DA's case. The district attorney's office said in a statement that it was disappointed with the outcome and would consider its next steps. It thanked the women for bravely stepping forward and recounting their harrowing experiences. Jurors were escorted out of the courthouse without speaking with reporters. I'm glad they talked to at least one of the attorneys. It offers insight. Masterson did not testify. Cohen presented no defense testimony and instead focused on inconsistencies in the accounts of the 3 accusers, who he said changed their stories over time and spoke with each other before going to police. And sometimes for jurors, that is going to be very difficult to overcome. That can be very difficult to overcome. If there were inconsistencies in stories, even though memories can change over time, that is going to be difficult. It's going to be difficult. And when you retry a case, that can get worse because you have the potential for more inconsistencies from previous trial testimony, which is why retrials are more difficult. The key to this case is not when they reported it, Cohen said during closing arguments. It's what they said when they reported it, which is an argument that undercuts the DA saying this is a delayed reporting case. He's saying this isn't, they delayed reporting it. That's okay. They delayed reporting it. It's that the stories changed. It's what they said when they reported it, what they said after they reported it, and what they said at the trial. So he was really focusing on changing testimony, or what he said is changing testimony. Mueller argued that Masterson was a man for whom no never meant no, which Reinhold, solid line, my guy. I'm just saying, it's a very solid argument that this is a person who has never known the meaning of the word no, especially when you got a celebrity case. 2 women said they were served drinks by Masterson and became woozy or passed out before being violently assaulted. One said she thought she would die as Masterson held a pillow over his face. We are not going to go through the rest of the recitations of the testimony. We're going to just get to their arguments. Cohen told jurors they could acquit Masterson if they thought he acted and reasonably believed that the women consented to having intercourse, Mueller countered that nobody would believe the acts described were consensual, reminding jurors that one woman repeatedly told him no, pulled his hair, and tried to get out from under him. Mueller told jurors not to be swayed by defense speculation and said contradictions in the victim's testimony were signs of authenticity as opposed to accounts that they had been scripted. Also, a solid argument. Why? Because saying that they're scripted, then you would expect it to never change. Like, this is the script. It's this and this and this and this and this. When there are variances, you're saying these are variances because the human memory works that way. The charges date from a period when Masterson was at the height of his fame, starring from 1998 to 2006 as Stephen Hyde on Fox's That 70s Show. The show made stars of Ashton Kutcher, Mila Kunis, Topher Grace, and is getting an upcoming Netflix reboot, That 90s Show. What? Wait, what? Wait, what? Not to get distracted, there's going to be a That 90s Show. I will watch that. I will watch that. I will watch that. For sure. Masterson is reunited with Kutcher on the Netflix comedy The Ranch, but was written off the show when an LAPD investigation was revealed in December 2017. So I'm going to answer some questions about this before we move on. Here's the thing. That split is heavily leaning towards acquittal, which might feed into the district attorney's office choosing not to retry it. If the alleged victims, and again, I was a DA, so it is hard for me. It is responsible for me to say alleged. There is a presumption of innocence until proven guilty. It is appropriate for me to say alleged. There are days when it is very hard for me to not just say victim, because that is how I spoke for 17 years of my life. For over 10 years of my life as a DA. So there are times you will hear me pause, because it is appropriate and responsible on the internet to make it clear that these allegations have not been proven yet in a court of law, and in a criminal court, and the presumption of innocence exists. The DA side of my brain never said alleged victim when talking about my cases, because they were the victim in the case. And it was known that case just hadn't been proven yet. So when you see a default in my language, it's because my brain is still catching up to making sure that the way I present things on the internet is responsible, and I'm not defaulting to the way that I always talked as a district attorney, which can be difficult. So Emily said, can the jurors give feedback like that after the fact? They can, at their choice. Jurors spoke to me after my cases all the time, told me what they thought, told me about things that happened in the jury room, told me about the discussions they had, told me what was important to them, told me what they liked or didn't like about my presentation, told me about what they liked or didn't like about my outfits, told me about, asked me where I got my water bottle or my coffee cup. Things haven't changed much. This would be the one on my counsel table now, people. This would be what was in the courthouse with me. But yes, jurors are allowed to give feedback like that, and it can vary by jurisdiction on how that's done. But generally, in Los Angeles, the judge will say, you're welcome to speak to the attorneys. If you want to, you do not have to. And that is that. So yes, they can. And it's very helpful to speak to jurors. The attorneys won't always speak to jurors. Sometimes the attorneys will choose not to, depending on the case. We had Emily, hold on. Back in the day of my very first felony trial, I was with a defense attorney that I very much liked. It was her very first felony trial too. We had all done misdemeanor trials and other felony hearings, but it was our first felony trial. The case was a mess. My only eyewitness, other than the police that showed up after the fact, my only eyewitness, because the victim did not come to court, my only eyewitness was difficult. And I will tell that story another time, but this is about talking to the jurors. So both of us were very interested to talk to the jury after this conviction. And she and I stayed around to talk to the different jurors. And then she and I talked about the case together in the hallway. Again, a defense attorney I very, very much liked and have a tremendous amount of respect for. So we were chatting and she's like, you're never going to believe this. I'm like, what? And she's like, The foreperson asked me out on a date. I'm like, wait, what? The foreperson asked her out. And she was like, I just lost. Like, this case was a mess. Like, this was a case where if they did not believe that eyewitness, that there was plenty of room for them to say, I did not believe that eyewitness. That eyewitness was a mess, but was so authentic. I believed him 100%. Obviously, I took it to trial. But I understand where she was just like, bro, what? Asked her out. So sometimes talking to jurors might not yield what you want. And she's like, he asked me out. And I'm like, well, I'm glad to know I won the case, even though the jury was distracted by your hotness. And I'm like, I understand why the jury's distracted by your hotness. You are a gorgeous woman. But the fact that we made it through this shit show of a trial, this thing, the ridiculousness of a trial, unlike anything I have ever seen, for all kinds of reasons, we made it through this trial, and the jury thought that you were much more attractive, and we still got a conviction. I was like, sometimes justice just needs to be done. Sometimes justice just needs to be done. And in this case, justice was done, but it was hilarious. And she was just like, really? So sometimes jurors will ask them out. Though I had a friend who was a DA who ended up marrying one of their jurors. Their jurors called the DA's office weeks after the trial and was like, I'm looking for DA so-and-so, and called and said, hey, I'm juror number such and such. Can we grab lunch? And the DA was like, sure. Married with kids. So there you go. I would rather a juror wait until after a verdict to ask you out instead of trying to do it in the middle of trial, when you then have to tell the judge and the defense attorneys on the record so they can then make fun of you about it for the rest of your career. Because that happened to me too. All right, let's keep going. So there is more. Mama C said, do all split juries end with a retrial rather than just a not guilty? Mama C, no. They don't all end with a retrial. The district attorneys can dismiss the case and choose not to retry it. So the DAs can dismiss it, which is not really a not guilty, it's a dismissal. There's no case pending. So they can dismiss it, or they can retry it. So those are kind of the two options. So Leanne G, are there ever trials where the jury is behind a one-way mirror for their protection? No, not in the US. You need to be able to see that jury. So no, not in the US. In other jurisdictions, could that happen? I don't know. It depends on their system. What are the cons of retrying a case? Well, you've got a whole nother case of testimony. We saw this in Depp v. Heard. In Depp v. Heard, we saw a lot of it where you had these binders especially when Johnny Depp and Amber Heard were testifying, you had binders and the attorneys are flipping through. Well, didn't you say in the UK this? And didn't you say in your deposition that? The more time somebody's spoken about an incident, the more room there is to point out inconsistencies, and those inconsistencies can matter to a jury. And so if you already have a jury saying we're leaning towards not guilty and inconsistencies played a role for us, then you add in additional testimony and it can make it worse. So I saw a lot of you asking, did the defense attorney go out on a date with the juror? No, she did not. At the time, she was dating a very lovely prosecutor and they were later married. So those are some of the downsides of retrying a case. So let's see. I put the lid on my coffee. I went to go drink it while I was looking at super chats real quick. Because I wanted to get to comments that were about this. Let's see. Louise asked about what we were talking about at the beginning of Quick Bits. What about channels who take clips from streamed courts and comment on them? If it's already been published on the internet, then it's just giving commentary on something on the internet, not a problem. The problem for like a Zoom court is if Zoom court is not broadcast on the internet, there is generally a prohibition against recording it or broadcasting it, so that shouldn't end up on the internet. But if it's already on the internet, if it's Natalie Lawyer Chick does a lot of court commentary. If the court's already been streamed to the internet, then you're just giving commentary on something that's already on the internet. So, Red Raven said, can we know the details about you being asked out? I've told this story before, so I never want to bore you with it. But I will briefly tell it. Did you ever prosecute a celebrity? Yes. And I had celebrities that were victims as well. I was in the middle of trial waiting. It's a much longer story, but I was waiting to go back into court. This was during a period of time where the judges and the attorneys were all fighting over who could use and not use the back hallways. The attorneys were saying, look, jurors aren't allowed to speak to us. And you can't even really say to the jurors, don't speak to me. It's so fucking awkward. But if you're all waiting for the doors to open to go into court, especially if you have a judge that's a stickler for time and you are me, you're waiting in front of those doors to open before court starts. At this particular courthouse, we used to use the back hallways where the judges' chambers were and would use the back hallways and go into the courtroom and be in the courtroom as the attorneys, like we saw in Depp Heard, be in the courtroom as attorneys before the jurors would come into the courtroom. So there wasn't worry about jurors potentially interacting with attorneys or jurors seeing attorneys interact with each other. So there was a war of the wills going on over the back hallways. And I was standing in front of the courtroom, waiting for the courtroom doors to open after lunch, because during the breaks, the juries just went into the juror room and it wasn't a problem. And this juror comes up and starts talking to me because they thought I was incredible and they thought I was an amazing woman. And they kept talking and I tried to walk away. And then I'm like, sir, you can't talk to me, which I can't talk to them. But by this point, the shit's already out of the horse. And they've already said so much that they're getting kicked off of this jury. So I'm like, sir, I cannot talk to you. And I was trying to walk away. And I'm like, you cannot talk to me. I'm trying to walk away because the judges tell them that they cannot. He was not hearing it. And I appreciated the compliments. They were very kind compliments. But then I had to tell the judge, and then I had to tell the defense attorney, and then all of them were like, well, we have to question the juror. And then the juror was removed from the case. They questioned the juror outside the presence of the other jurors, but it was in the middle of my case. Please, not in the middle of my case. Thank you for the compliment. Tell me after. Don't tell me in the middle. Even if it's like, where did you get your water bottle? I can't answer you. Even if a juror walked up and was like, oh my God, love your shoes. I can't engage with you. It doesn't matter if it's about the case. It doesn't matter if it's about the weather. It doesn't matter if you see me bleeding and are like, hey, you're bleeding. You can't talk to me about anything. Do not look at me. Do not talk to me. Do not engage with me at all. It doesn't matter if it's about the case. It is improper. And I think it's hard for humans to understand, because when you're awkwardly standing waiting at a door, a lot of humans want to have a chat. You can't, which is why the back hallway was so needed, which is what we told the judges. This is why we need to be in the back hallway, because people are going to be overwhelmed with my beauty. It's not the only time I was asked out in court, though. There were other times. I got asked out a lot at work when I was pregnant, which was odd to me because I had never felt more horrible in my life. I see all of you asking, but would you go out with the juror? I was very married. And when I'm wearing a wedding ring, maybe don't ask me if I need a little something on the side. I don't. I have books. Dr. P and I are good. No, but I got asked that a couple times. Just don't. Vicky Lou said, I didn't know that, Emily. Interesting. Yeah, it is just all of it. Elle Woods and the shoe scene with the witness should have been brought to the attention of the judge. Don't stomp your little last season Prada shoes at me, honey. That should have been brought to the judge's attention. So no. Are the jurors instructed that they cannot talk to the attorneys? Yes, they are. They're instructed that they cannot talk to the attorneys, the witnesses. They are instructed, and they are instructed daily. Daily. But I got offered, I got propositioned a lot. People offered, they're like, if you ever need a little side piece, I'm like, Thanks. I'm good. And this is not unique to me. This just happens. So I think we closed out the topic of the Masterson trial. I will keep an eye on what they decide to do. I will be asking around. I'll probably reach out to Reinhold and be like, "Hey, Reinhold, when y'all decide, will you just let a girl know? Like, if there's an official press release, will you just please tell media relations to also send it to me? I'd like to know." And I liked your statements. The AP, I think, quoted you well. Maybe Reinhold and I were in training together at the DA's office. All right, let's go. Let's see. Laura, Emily, your gorgeousness, you're gorgeous, let's speak. So I don't think so. I appreciate it. I think I'm a whole lot of fun. But would I put myself in the category of people who are just like, damn, that person's attractive? No, I don't think so. But thank you. I can understand that I'm charismatic. We make up for it by being funny. But in court, I was generally not as funny because I got yelled at if I was funny. So yeah, a lot. Let's move on. We have more quick bits. I don't know where we're at with the Kardashian poll. We're not going to close it yet. Take a vote if we're talking about the Kardashians or not. Y'all have a few more moments to vote. We got a few other topics I want to cover. Even though we're an hour and 10 minutes in, we're going to try to do it quickly. Oh, shit. I'm going to run out of time. All right. We're going to do one, and then we got to get to Erika's earrings. TikTok Meta. We're going to talk about Meta. We'll talk about TikTok next week. I got to move faster. Sorry, y'all. Today is a full quick bits show. No, we got to get to Erika. But I did want to talk about this. Meta hit with $275 million GDPR fine over data scraping claims. There are two cases. TikTok's going to get bumped. There is a new TikTok lawsuit, and I've seen that TikTok is being banned on different phones for government employees. I don't remember which state it is. We've got a lot to talk about with TikTok, but that's a longer conversation. So we're going to get to the new TikTok lawsuit on Tuesday. So the poll, you guys are like, the poll wasn't clear. The poll should be, are we talking yes or no? Are we talking about Kim Kardashian? So if you want to talk about it, yes. If you don't. We're going to have to talk about the TikTok. TikTok is being banned on work phones, which I also think is appropriate. But we're going to talk about Meta. We'll talk about TikTok on Tuesday. Sorry. We have to talk about TikTok on Tuesday. Law 360, Meta Platforms has been fined $275 million for violating Europe's GDPR regulation by allowing the personal data of more than 500 million Facebook users to be scraped from its network and posted on a hacking form, Ireland's privacy commissioner said Monday. 500 million Facebook users.
500 million Facebook users. What?
Is Meta Facebook? Yes. Meta is the parent company for Facebook. Zuckerberg changed the name to Meta because he wants to control all of our things in the metaverse. Look, could you keep the things you have safe? Maybe. Keep that safe first.
500 million users. Which hacking form? I want to know.
Maybe they didn't say it because they don't want people going to look for it. Is that like 500 million people? Yes, it's all. Between May 2018 and September 2019. Oh, so it went on for just a week or so. I'm teasing. It went on for fucking ever. Can I give you my recommendation? Here's one of my recommendations. If you are signing up to social media networks, which we are going to do, we're here, get a Gmail account that is like, I don't know, not your name, not identifying, not connected to any other email that you use, and start your own just random ass Gmail, like random ass 326 at gmail.com, and use that for your social media handles. So at least you have one email that if it gets infected, it's infected. If you get a Google Voice number and use that as the phone number to sign up, at least there's layers of protection to your data. Things I wish I had known when I started all of my stuff. But that's what I do. I use a email that you cannot find anywhere on the internet that is my email for social medias. And then I use other numbers because it is a way to do it. So, yeah, an email for the randos. Yep. And it's an email that I use because if that email gets hacked, it's not connected to literally any of my other shit. Because you've got emails that are connected to your other shit. The email that you're using for social media should not be the email that you're using for your bank accounts. Because if they get into that email, they can get into everything. Have multiple email addresses. If you're going to sign up for your rewards program at the grocery store or at where you like to shop, put it on the random social media email. Put those things on that. A separate email for your banks. Shalene Johnson talks about this a lot. When her Facebook got hacked, it took down everything. And she talks about it quite openly, and it has a podcast episode about it. It's very helpful. So Jenny said, you can also use an email alias so they don't have your real email. Apple's doing this really easily. So Apple's doing this really easily. Ellen said, you use emails for bank accounts? Yes. A lot of the bank logins are emails. Also, yes, enable two-factor authentication. Chat, we are so open to all your suggestions. Also, use the incognito mode. Yes, I also use a VPN. Yes. So all of you guys have great tips. How do you recommend storing strong passwords? I use LastPass. Not a sponsor. I use LastPass. That's who I use. LastPass has some great emergency features. Look, I'm a lawyer. Oftentimes I think, what would happen if I got hit by a bus tomorrow? How would everybody do the things? LastPass has some great emergency functions, and I can have my parents use LastPass so that if I needed to access their stuff in an emergency, I can. That's why I picked LastPass. They have had less problems than others. So I enjoy working with Nord. I like two-factor authentication. There are lots of password managers. That's the one that I use. So we talk about death folders. We have talked about the death folders. We have. Just wipe my fucking Kindle and my Audible. And then everything else is fine. And then everything else is fine. You need a friend, the friend you can tell to wipe things. Wipe the things. My mother doesn't need to know. All right, let's keep going. Let's keep going and talk about this real quick before we move on. Between 2018 and 2019, scrapers exploited a tool designed to help Facebook users easily connect with their contacts to sweep up a trove of personal data, including users' full names, locations, and birth dates. According to Ireland's Data Protection Commission, the tool, which has since been phased out, breached GDPR's Article 25, which requires that companies build data protections by design and default. The Irish regulator, which had been investigating Meta and Facebook since April 2021, said Monday that its enforcement action against Meta requires the company to take a range of specified remedial actions within a particular time frame without providing more details. Right, because if you provide more details, people are going to know where the flaws are. You've got to give them time to fix the flaws before you detail the flaws. Yeah, you can't provide more information on that. The DPC, which serves as Meta's lead GDPR authority, because the company's EU headquarters are in Dublin, has been criticized by privacy advocates and other EU watchdogs for not being aggressive enough with its enforcement measures against Meta and other tech giants like Google, Twitter, and TikTok. With Monday's fine, the DPC has levied penalties of nearly $1 billion. $1 billion. $1 billion. Against the Meta-owned company within the past 14 months. In September, the DPC announced plans to impose a $401 million fine on Instagram for allegedly mishandling children's data on the platform. A move that followed a September 2021 decision to fine WhatsApp $267 million for failing to be transparent with users about how it discloses their information. Meta is appealing both of these rulings, but the company declined to say on Monday whether it would also challenge the latest fine.
Okay, but if you're going to appeal, maybe also take their advice. Maybe also just take their advice. Maybe also.
Unauthorized data scraping is unacceptable and against our rules, a company spokesperson said in a statement, and adding that Meta is reviewing this decision carefully. Data scraping has been the subject of several lengthy battles, or several legal battles in the recent years, including one high-profile case in which the Ninth Circuit found in April that a job search startup, HiQ Labs Inc., did not breach the Computer Fraud and Abuse Act by scraping LinkedIn profile data to build its own data analytics product. So scraping is interesting. We're going to have to take a look at it more. Privacy advocates and defense attorneys have told Law 360 that the mass scraping of publicly available data like email addresses and phone numbers often falls outside the scope of the patchwork of U.S. state breach notifications. Here's the thing. The U.S. does not yet have a nationalized GDPR law. And while I am a less government regulation kind of a girl generally, I think it is irresponsible to have companies have to find what each state wants and be able to manipulate that. I think when it comes to the privacy and data privacy, there are some things that should be standard across the board. So it doesn't matter that California's rule is this and Idaho's rule is that and Kentucky has a different rule. Could we just have some things just need to be centralized. What those rules should be is a whole different conversation, but there are so many different ones that it makes it really hard for companies, and then things fall through the cracks, which also sucks. To fall through the cracks of a patchwork of U.S. state breach notification laws, which are usually triggered by a disclosure of identifiers like social security numbers, bank account data, or passwords, cybersecurity experts warn that malicious actors can use aggregated public information to fuel social engineering schemes in which attackers aim to lure people into divulging sensitive data and are generally very successful. So there should be some centralized rule for how this goes, so at least the public knows what's protected and what's not protected. Let's be transparent. That's all. Let's be transparent. What data are people getting and how? So that you know. Let's just let people know. Okay, with that, can we end our poll, Miguelina, about the divorce? And I'm going to start pulling up Erika's earrings because, oh my God, it's 12:35. And there is so much more to cover. So we're going to have to switch topics because I've got to zoom because then I've got another hearing. So let's see. Cricket. The moment my divorce was finalized, my ex's attorney asked me out before we even got out of the room. Did you say yes just out of spite? Is that petty? I'm sometimes I can lean into the petty. Kim K divorce, no 54%, yes 45%. Okay, I will touch on it on other socials and we will move on today. It looks like Kim is getting like $200K in child support. That might be reevaluated because if Kanye's income has substantially declined, then that might be reevaluated. We have a whole bunch of things to get through. We're not going to get to all of them today, but I'm going to zoom to the interesting bits. That's how we're doing this. We're not going to do a whole deep dive. We're going to zoom. Erika Girardi's earrings. You've heard a lot about Erika Girardi's earrings. Erika Girardi's earrings are slated for auction later this month. They are slated at a much lower price than paid for. However, that doesn't necessarily mean that they are the same or not the same earrings. Law and Lumber, I'm not shocked by this. I've been asked out by clients after handling their divorce. It can be uncomfortable. As the attorney, I imagine that it can be uncomfortable. You're like, I appreciate that, but you need a moment. Rob's like, I have a no dating clients policy, and different state bars actually have rules about it. California's rules are surprisingly lax. You just can't exchange that for client fees. So with that, let's see. Erika Girardi's earrings have been turned over, slated for auction, not at the retail price that Tom Girardi paid for them, but at a lower price. I talked about it over on Rob's stream on Friday and my thoughts on it. There is still an appeal pending about whether the earrings should have been turned over, should not be turned over, and should be sold. Still a discussion going on. That's what we're looking at today. We're looking at the appeal. We're looking at the appeal for it. Erika Girardi versus Elisa D. Miller, the trustee. This is a kind of a counteraction because the trustee sued to get the earrings. The trustee is going after other things. So this is the appeal with regard to turning over the earrings. Again, table of contents, zoom. We're going to go to the statement of the issues in the case. summary of the argument, and that's about it. We're not going to go through all the legal, but I'm going to go through the table of contents for it. The bankruptcy court erred as a matter of law when it determined that the trustee's claims were not barred by the applicable statutes of limitations. So this shit's too old, you can't take the earrings. The bankruptcy court erred as a matter of law when it determined that the trustee's turnover motion applied to the earrings. Not these earrings, not now. And then the conclusion. So we're going to go through the things that set the stage for us and then move on. We don't need the jurisdictional statement. We're in the bankruptcy court. Statement of the issue. The bankruptcy court erred as a matter of law when it determined that the trustee's claims based on an alleged fraudulent transfer of property over 15 years ago was not barred by the statutes of limitations and statutes of repose. Standard of review is de novo. Second issue. The bankruptcy court erred when it determined that the underlying property subject to the turnover motion was property of the bankruptcy estate and that the turnover motion was a proper basis to compel the return of the alleged property. Standard of review is de novo. Statement of the facts. In 2000, Ms. Girardi married Tom Girardi when she was 27 years old and he was 60. I thought she was older than that. I thought she was older than 27 when they got married, but I could be wrong. During their marriage, Girardi and his firm, Girardi Keese, handled all of the couple's marital finances. Ms. Girardi is not and has not ever been an attorney. Her career during her marriage was as an entertainer. See her declaration. In approximately 2004 or 2005, as a gift of either Ms. Girardi's birthday or the couple's wedding anniversary, sounds like she doesn't remember, Tom gave her a set of diamond earrings. About a year later, Tom and Ms. Girardi's home was ransacked while they were out to dinner and the earrings were stolen. Subsequently, in 2007, Tom gave Erika a replica of the earrings that had been stolen. It's interesting that they said replica and not replacement, but there might be nothing there. That might just be a word choice. In November 2020, Erika filed for divorce against Tom and moved out of the couple's residence. Since that time, she has been living in a rental, and her principal assets are her personal belongings, including her jewelry, and her income as a cast member of The Real Housewives of Beverly Hills. In December 2020, creditors of Girardi Keese filed an involuntary Chapter 7 bankruptcy against Girardi Keese as well as Tom Girardi. The bankruptcy court appointed the trustee. About a year later, Erika learned for the first time that the replacement earrings, not replica, replacement earrings she had received in 2007 were allegedly bought with money transferred from a Girardi Keese client trust account for the Resulin litigation. There's a check. We saw it. We saw the check. I mean, I understand their parsing of words, but we saw the check. Erika had no involvement in or knowledge of the actions of Tom or Girardi Keese in connection with the litigation and the Girardi Keese trust account or the Girardi Keese trust account in the litigation. I think that's fair. January 25th, 2022, the trustee filed a motion before the bankruptcy court under rules for an order compelling the turnover of the earrings. On June 14th, Girardi filed in opposition to the turnover. In opposition, Erika alleged that 1, the statute of limitations and statute of repose had expired and barred the trustee's claim on the 2007 earring transaction. 2, the turnover motion was improper because the Girardi Keese client trust account and in turn the earrings were indisputably not the property of the Girardi Keese bankruptcy estate. In June 21st, 2022, the trustee filed her reply brief. In June 28th, 2022, the court held a hearing on the motion, and July 11th, 2022, entered its order granting the motion. July 25th, Girardi filed a notice of appeal. Introduction and summary of argument. We looked at the arguments. They're saying that too much time has passed. I got yeeted. I have no idea. I have no idea how I got yeeted, but I got yeeted. Apologies. Today's going to be a tech day. So there's two arguments here. One, that the earrings aren't the property of the bankruptcy court, and 2, that the statute of limitations had passed. Those are the two arguments here. Let us continue on. Let's see. We're going to go to just the main arguments. The bankruptcy court erred as a matter of law in granting the turnover motion. The trustee's claim was and is time barred by the statute of limitations. The trustee's claim arises out of a 15-year-old transaction, specifically California's UFTA, as codified in the California Civil Code, establishes a 7-year statute of repose applicable to all cases of action or all causes of action relating to a fraudulent transfer. That's going to be hard to get around. The California legislature's statute of repose, 1, creates an insurmountable time bar to the turnover motion, and 2, applies regardless of how the fraudulent transfer is described under common law. In addition, trustees' claims fall outside any applicable statute of limitations for the reason that Girardi Keith's knowledge of the 2007 transfer is imputed to the trustee, who stands in the shoes of the debtor. Thus, Girardi Keith's undisputed knowledge of the transaction at issue in 2007 commenced on the accrual of any cause of action related to the transfer of funds, which led to the acquisition of the earrings. The law firm knew that it took it out of client trust of funds in 2007. The law firm was not defrauded. The law firm did this. So they're arguing that the law firm knew in 2007 they weren't hindered with this. They weren't surprised by this. A straightforward reading of the relevant bankruptcy statutes, legislative history, and applicable case law all compel the conclusion that the bankruptcy trustee is charged with GK's knowledge in 2007. Therefore, the delayed discovery rule is inapplicable. Just because the trustee didn't know about it until the trustee became the trustee and found the check doesn't mean the law firm didn't know about it. And the trustee is given the knowledge of the debtor, and the debtor knew in 2007. Here's what's hard about this case is that the right result legally might be a result that we hate. And that is when the law is hard. When the legally proper result and things that we like are two different things. And this might be a legality and a morality is the thing. Law and Lumber says argument to toll the statute of limitations because of a cover-up preventing discovery. They wrote a check out of the client trust account. What would have been covered up? Like, they wrote the check. So that's the argument for Erika's team. They wrote the check. They wrote the check. They didn't hide the check. They didn't hide it from their books. But I appreciate it. I think the bankruptcy trustee is going to argue it. And notice Erika has not made a stay to not sell the earrings. But if she wins this, she'll get the money back that they earned from the earrings. So, 7 Lil Boo 7 said nothing should be this complicated. Law. Because law. This is how lawyers get paid. All of this. But here's the thing for Erika. This is where I try to keep two frames of mind, because Tanya said it. Erika doesn't want to part with those tacky earrings, doesn't she? No, Erika does not want to part with these earrings. Here's why. Erika's a long way from done with the other shoe dropping, because the IRS and the Franchise Tax Board are coming and will come for Erika and her companies. If Tom was doing all of this and Tom was in charge of all of their books, the Franchise Tax Board already says Erika owes over $2 million, or the marital estate, which she is still a part of, already owes over $2 million to state taxes. She is going to need every asset she has to pay off what's coming down the road. So I understand that her lawyer's looking out for her best interest, because her lawyer's job is to look out for her and no one else. Her lawyers are going to try to keep all of her assets because she is going to have other shit she has to pay. And the more assets she keeps, the more she is going to have to pay. So I think they're allowing it to be sold. If they win on this, they'll take the money back. And that money's not going to stay with her. That money's going to have to go to somebody else, the IRS or the Franchise Tax Board. So she is trying to hold on to all of her assets because she is a long way from done with the crater of debt that she's gonna be stuck with. And I have another point. She is going to be on the hook for the personal bankruptcy as well. The judge has said that the personal debts aren't going to be discharged. So on the Tom Girardi side, not the law firm side, but on the Tom Girardi side of the bankruptcy, Erika is going to be left. If the vet for the racehorses in Florida doesn't get paid, she's going to be left with that debt. If the private security that's a debtor or a creditor in that case doesn't get paid, she's going to be left having to pay for it. So the discharge isn't happening. She may later have to file bankruptcy to get rid of those personal debts. So she is a long way from done. So I understand why she's fighting it. On a PR side, it's a fucking nightmare. On a PR side, this is a nightmare. On a legal side, it makes complete and perfect sense, even though it's a PR nightmare. And that is where Erika is in a very difficult position. and her behavior on the show counts against her, and people aren't generous with, I think this is distasteful, but I understand that this why you're doing it legally. People are giving her no slack because she says shit like, I don't give a fuck about anyone but me. Well, honest. Second, the turnover motion was improper because it is undisputed that the earrings and specifically the funds used to purchase the item were never part of the bankruptcy estate. They're saying that the money here, notably the funds in the Girardi Keese client trust account, are and were never property of Girardi Keese. They were property of the clients. And as a matter of law, the trust funds were not the property of the Girardi Keese estate on the date of the involuntary bankruptcy petition. Let that sink in for a second. Let that sink in for a second. The argument of the lawyer, this is lawyer. The argument of the lawyer is that the money used to buy the earrings never belonged to the law firm because it was client funds. And because it was client funds, the bankruptcy trustee cannot claw back the earrings because they were bought with client funds, not funds that the law firm was ever entitled to. And the statute of limitation is passed, so the clients whose money was taken can't go back and sue. What the fuck? What the fuck? They are acknowledging that the money is the client's. This money was never property of Girardi Keese. The money used to buy the earrings were never Girardi's money. It was the client money. I agree with you, Lawn Lumber. I disagree with that argument entirely. They became property of Girardi Keese when they converted them. I agree with you. When you wrote the check out of the client trust account for your own purpose, you took it. But they're arguing, yeah, he took it, but it's too late. The fuck? Okay, so that's the argument. That's the argument. What's interesting is they're not arguing what they argued earlier. I keep sidebarring myself. What they're not arguing is what they argued earlier, which is these were legal fees that were owed to Tom, so he didn't really steal client funds. So the statute of limitation is passed. The funds, I'm just going to read it one more time because here's the tea. The funds in the Girardi Keese client trust account are and were never property of Girardi Keese. They were the property of the Girardi Keese clients. As a matter of law, the earrings were therefore stolen. No, fuck, that's not what it says. Hold on. Back up. That was me interjecting. As a matter of law, the trust funds were not the property of the Girardi Keese estate on the date of the bankruptcy. This is because Congress determined under Section B1 of Section 541 that property of the estate does not include property over which a debtor exercised power solely for the benefit of an entity other than the debtor. The benefit of the clients, the clients, $750,000 of their money was used to buy fucking earrings. And your argument is, well, it was the client's money. You can't take the earrings. I understand that lawyers have to make these arguments. It doesn't make it easier to wrap your head around. So go find the clients and give them the money. That's not what they're arguing either. Following the statute, the Ninth Circuit has long held that bankruptcy law does not view property held in trust by the debtor as property of the estate available for general creditors. But you bought earrings with it. It wasn't still in the trust account. If it was still in the trust account, it would go to the clients. It's not still in the trust account, which I imagine is what the trustee is going to argue, but we're not going to get there today. We just simply do not have time. We're not going to go through the arguments. We're just going to go to the conclusion. This gives us where we're at. This kind of sets the stage for what you're going to see next. Because I want to get to the... If we need to deeper dive on this, I'll probably do a podcast episode and summarize these instead of going through them line by line. Because I think it would be a real interesting podcast episode to go over the real tea behind these. Let's see. Where's our wrap up? The turnover motion fails because the Girardi Keese client trust account funds used to purchase the earrings were and are not property of the bankruptcy estate. The trustee concedes that an attorney's client trust account, such as the GK trust account, is an express trust, which is defined as a fiduciary relationship whereby the trustee holds property for another's benefit. Tom Girardi spent it like it was fucking water by all accounts. However, subsection B1 of 541 provides that the property does not include property over which the debtor exercised power. So it's excluded. Boy, oh boy, because the Girardi Keys client trust account at issue is not and cannot be property of the estate, the trustee cannot now use a motion to turn over under section 542 to end route only potentially proper claims, which are fraudulent conveyance claims. So that's the only, you have to make fraudulent conveyance claims. As noted, the fraudulent conveyance claims are barred by the statute of limitations. You can't argue it that way. You have to argue it's fraudulent conveyance. And if you argue it's fraudulent conveyance, it's too late. That's the argument being made on appeal. So when Andy Cohen is like, but you're appealing the turnover of the earrings, Erika's like, we're appealing for legal reasons. They're trying to reset the stage and say it's client property. So it's fraudulent conveyance. Theft. It's fucking stolen. But if it's fucking stolen, it's too late. That's the argument. That's the argument. That's the argument. That's the argument. Okay. We haven't gotten to the emails yet. The trustee responded. We're just going to go through what their arguments are in a line because I do not have a ton of time left. And Miguelina, I know you also had a hard stop if you need to go. I promise I will wrap up like a responsible adult. Here's the summary of the argument. Mr. Girardi does not have a legally protectable interest in the earrings and lacks standing to object to the turnover motion. Bitch, those ain't yours. She doesn't even go here. Those are the victim's funds. They were stolen by Girardi Keys. You have no room to object because you don't own them. Mr. Girardi does not have an ownership interest in the earrings, lacks standing to claim rights. The statute of limitations and statute of repose do not bar the trustee from recovering the earrings, does not apply. The reliance on the statute of repose is unavailing. In refusing to release her interest in the earrings, Girardi is in violation of California Penal Code 496, receipt of stolen property. If I remember that correctly, I think so. Mr. Girardi holds the earrings in a constructive or involuntary trust. Okay, perfect. Thanks, Miguelina. I read times wrong. I'm bad at time. Girardi's fraudulent concealment of the embezzlement precludes application of the 3-year conversion statute of limitation. So here's the concealment argument. It's bad when you're Erika Girardi. It's bad when you're Erika Girardi, and the argument is they didn't conceal the fraud. It was just out in the open. Okay. Mr. Girardi's reliance on impari delicto is misplaced. The trustee's motion is the proper vehicle to recover the earrings. The trustee has satisfied the burden of proof. Conclusion, certificate of compliance. So this is the objection, the opening brief. So we're in an appeal. Opening brief, responsive brief, or opposition brief, and then we're going to get a reply. We're swooping. God, this weather is killing me. It is so dry. There are days I'm like, I can't wear lip gloss today. My lips are just way too dry. Even though my lip gloss is not sticky and is lovely. It is so dry. Tom Girardi is the disgraced and disbarred attorney. Here comes the bankruptcy trustee with the smoke.
Thomas V. Girardi is a disgraced and disbarred attorney who embezzled millions of dollars from settlement funds deposited in his law firm's client trust account over a span of years.
Girardi's embezzlements from the Girardi Keys client trust accounts were repeated and wholesale and ultimately contributed to the bankruptcy of Girardi and Girardi Keys.
This case arose from one such embezzlement. I added one such. This case arose from Girardi's embezzlement of $750,000 of the Resilin client trust account deposited into the trust account were the settlement monies paid for the benefit of the clients who were victims of the overprescribed diabetic medication Resilin. Girardi took $750,000 of those funds to purchase large diamond stud earrings that he gave to his wife, Erika Girardi. The trustee's account ledger also states that the firm paid itself $7.5 million in fees.
7.5 million in fees and 15 million for costs.
Pay for the earrings out of your fees. Here's how this goes. A case settles for whatever amount of money. The case settles. The attorney takes their fees first. In this case, 40%. 40% of the settlement, they take it. Then they take their costs. Then whatever is left over goes to the clients. So if 7.5 million was 40%, how much would the total settlement be? Maths, law nerds, can you math for me? Can somebody backwards math it? Because I'm curious as to how much this total settlement would have been if 7.5 million is 40%. They take fees, then cost, then the leftovers. I think they should have to take costs first, then fees, but everyone's going to fight me on that. I think they should have to take costs first. Why? It incentivizes them to keep costs low because you take 40% after cost. That's just me. Call me crazy. Your fees go second because 7.5 million is what? Fink, I trust you, 19 million. So if 7.5 million means the settlement's roughly in the 19 million range, then the clients aren't getting much, because if it's roughly 19 million, even if it's 20, they took 15 million for costs and 7.5 million for fees. So what is left over between those and the settlement is what goes to clients. So you guys are like 18.25. So what's left over for these clients is probably not a whole lot, because this is probably a whole lot of clients. So this is why you see those class action settlements. And it's like, you've been part of this class action settlement. Here is your $7. This is why. This is why. This is why. Because Girardi remained in control of the debtor, the embezzlement went undetected until the trustee and her team reviewed the trust account ledger. But that goes to the argument that he knew and it wasn't concealed, and questioned the $750,000 entry described as cost of the litigation, which in fact was a payment to a jeweler for earrings. Maybe that's the cover-up. Maybe that's the cover-up, that they were listed as costs. Upon discovering Girardi's theft, the trustee immediately advised Ms. Girardi of the findings and requested a return of the earrings so that the value could be preserved for the benefit of the estate to go to other creditors. Ms. Girardi refused, asserting that she was entitled to keep the earrings. The trustee then filed the motion to get them back. The motion was granted, the bankruptcy court finding the use of the trust fund was an embezzlement and a fraud from day one. That's the direct quote from the court. And that Erika is still in possession of stolen property. Namely, it went directly from the account to buy the diamond earrings, and it's stolen property. Girardi does not dispute the bankruptcy court's factual findings. It is stolen property. I'm not saying allegedly, because it's not alleged stolen property. The earrings are stolen property. Rather, Ms. Girardi grounds her appeal and her claim of ownership of the earrings on two legal positions. One, the trustee's claim is barred by the statute, and two, the earrings were not the property of the estate. Girardi's misappropriation of client funds constitutes a serious ethical and moral violation, breaches of the high duty of loyalty which an attorney owes to his clients, violates basic principles of honesty, and puts in peril the public's confidence in the legal profession. Facts. Under such circumstances, the California Supreme Court has determined that the statute of limitations for claims based upon such conduct does not begin to run until the beneficiary, or here the successor trustee, has knowledge or notice of the dishonest conduct. That knowledge did not occur until late 2021 when the trustee discovered it. In addition, because of Girardi's
massive fraud,
it has yet to be established whether the earrings were paid with funds due to the clients or the firm. Commingling trust funds are categorized as property, or commingled trust funds are categorized as property of the estate unless a tracing establishes otherwise. The burden of the tracing falls on Erika, and this she failed to do. Moreover, Mr. Girardi has neither legal nor equitable claim to the earrings and therefore lacks standing to assert her claim. We don't get to argue standing very much, but here we are. Standing. You don't go here. This isn't for you. You can't speak here. You don't have standing. That shit's not yours. Her refusal to turn over the stolen property upon demand when told of its status is a crime. Freshly committed.
Fresh crimes. I mean, it would be probably treated as a misdemeanor in Los Angeles because it's only $750,000, but crime. It's a crime. It's a 496 receipt of stolen property.
Her refusal to turn over the stolen property upon demand when told of its status is a crime freshly committed under California Penal Code 496A and under 496C, and it subjects her to treble damage civil liability. All. Mr. Girardi's arguments on appeal are without reason and without substance, as Judge Russell stated, the bankruptcy judge. I think, hold on, we've got a block of something going on over on Facebook. We're good. People just wander through Facebook and are like, "Hey, my WhatsApp number is this." No. As stated by Judge Russell, I think the cases are clear that the trustee, at least for purposes of what we're talking about, has at least enough legal interest in it at the point to have standing, because as a practical matter, who else would there be? So the trustee has standing, but no one else. The trustee's right to possession of the earrings are superior in law and equity to Erika's desire to maintain her rich and famous lifestyle. Ouch. Footnote 1. Mr. Girardi is and has been a regular on the glam reality television show Real Housewives of Beverly Hills. Appellate's opening brief, AOB at 9:22. Statement of the issues. Girardi's appeal challenges the bankruptcy court order granting the trustee to turn over the fucking earrings. Procedural history. Bankruptcy happened on December 18th, 2022, and voluntary bankruptcy petitions were filed against Girardi and Girardi Keys. The filings followed a December 14th, 2022 determination by Judge Thomas Durkin in Illinois that Girardi had stolen $2 million in settlement funds that were paid to Girardi Keys clients in the Lion Air crash. So, not allegedly stolen. I told you, Illinois did all of it. If this hadn't happened in Illinois, if it hadn't been brought, and I talked to Jay Edelson of Edelson PC, if Edelson PC hadn't brought that motion, I don't know if this would have fallen down like this. I don't. It might have fallen down, but not like this. Subsequent to the filings, the bankruptcy court entered an order for relief. Bankruptcy trustee was appointed. The trustee commenced a review of the debtor's books and records. The review led to the discovery of a 2007 embezzled $750,000 from the trust account, using money to purchase earrings to replace an uninsured set stolen from the Girardi residence a year prior. Footnotes 2 and 3. Resilone was a diabetic medication sold by Parker Davis. I think this was $1 billion settlement. Hold on. I need to. That's not right. The ADHD is real. I need to know this. They were probably part of a much larger, I don't know if they were the class leader, a much larger settlement, but these types of settlements are generally reported. So, let's see. I'm trying to see if we can look at the settlement funds, because I think this was one of the bigger ones that they were advertising on their website, but I don't remember. I will have to go back and look. I think this was a overall class $1 billion settlement. But I'm not sure how much it was. Was it a $66 million settlement? This was a big settlement. I just need to go back and find it. I'm gonna research it. I need to make a note. Anyway, we need to keep going. 3 years later, the company withdrew the drug from the market due to high level of liver failures and deaths associated with it. Girardi represented over 1,000 people harmed by the use of the drug and was one of the lead lawyers in the mass tort case. Under California law, embezzlement is the fraudulent appropriation of property by a person to whom it has been entrusted. under 503. Embezzlement occurs when an owner entrusts property to an individual and the individual conveys the property for their own benefit, like writing the check directly out of the trust of funds for earrings. The trustee then provided Erika with the documents evidencing the improper use of funds, the fucking check that said it was for costs. And of course, the clients aren't going to know. There's $15 million in costs. Who's going to find $750,000 amongst $15 million? They're not. The client trust account, the improper funds from the client trust account and demanded that she return the earrings so that they could be liquidated, the proceeds therefrom properly administered. So administered to not the resident clients, but administered to clients or to creditors in the order of bankruptcy that they get distributed. Claiming the trustee's information was the first she learnt that the earrings were purchased with funds embezzled from the debtor's trust account, Erika refused to relinquish the earrings, contending that too much time had elapsed for the trustee to recover the stolen assets and that the trustee did not have standing to assert the claim. The trustee was left with no choice but to file a motion, and then this all became very public. I don't know. I don't know if the money's worth the PR nightmare that this is. I don't know. I don't know. Yeah, I just don't know. The trustee filed her motion on January 25th, 2022. We covered it, together with a request for judicial notice. Girardi responded by filing a preliminary opposition. We've gone through the filing in the other motion, statement of facts. Upon her appointment, I want to know what they were doing. Upon her appointment in January 2021, the trustee retained the services of Development Specialist, Inc., DSI Consulting, a forensic accounting management consulting firm, to conduct a review of the debtor's books and records, footnote 5. The trustee also retained Daphne Mason as her field assistant or field agent to assist the trustee in the operations of the estate, including but not limited to locating records to support Quantum, Merowit, and other claims. The investigation led to the discovery of the following documents and facts. A letter written by Girardi dated July 6, 2012 to Ms. Zinzu of the California Franchise Tax Board, in which Girardi represents to the Franchise Tax Board that in 2007, Girardi had purchased the earrings for $750,000 using a line of credit Girardi has established at Comerica Bank. So Tom Girardi, it seems, lied about the source of funds to the Franchise Tax Board. Girardi also provided the FTB with a declaration from the jeweler, M&M, the owner of the jewelry store where the earrings were purchased, affirming the purchase and the cost of the earrings. Those exhibits are attached. We've already seen them. We looked at them over on Rob's stream too. A March 2, 2007 check drawn on the trust account at Comerica Bank. Wait, same bank? It would say trust account though. Your trust Your trust account is not a line of credit. Your trust account is not a line of credit. The fact that he would tell the Franchise Tax Board that the trust account is a line of credit at Comerica Bank is just fucking boggling. Ah! Fucking Tom Girardi. Telling the Franchise Tax Board that it's a line of credit at Comerica Bank and drawing it out of the trust account. The check should be attached. It says trust account. A March 2, 2007 check drawn on the trust account at Comerica Bank in the amount of $750,000, payable to M&M. The check signed by Thomas Girardi and James O'Callahan. 2 people signed off on it. The back of the check presents the check was negotiated and deposited into the account of M&M Jewelry at First Republic Bank. A Girardi Keys trust account ledger for the Resilient Mass Tort action, setting forth the following entries for March 2nd, 2007. Date, transaction type, check number, payee, M&M, description, cost, amount, $750,000. Your earrings are not costs. Because the costs, just so I can make it perfectly clear Even though someone in the comments, not a law nerd, someone swooping by, is going to say I'm repeating myself. Just to make it perfectly clear, when these settlements come in, the lawyer takes their fees off the top. Then they take their cost. The clients, the persons who are injured, get paid the leftovers. Fees, costs, leftovers. So taking the $750,000 as costs means that the clients get less in their settlement action. That's what it means. The 1,000 people represented get less because of these earrings. Girardi then gave the Tom gave the fucking earrings to Erika. A complete review demonstrates that Girardi Keys paid itself $15 million as cost, $7.5 million as fees from the money deposited in the trust account. Girardi claims, which amounts to a partial admission, that in late 2021 or early 2022, she learned for the first time that the replacement earrings she received in 2007 were allegedly bought with money transferred from the trust account in that litigation. The trustee requested that Erika return the earrings. She was disinclined to acquiesce to that request. Summary of argument: embezzlement is fraud. So give it back. Embezzlement is fraud, give it back. That's the summary of the argument, because we have to keep going today or I'm going to be late. And then Erika lacks standing. Let's go back up to why Erika lacks standing. Girardi committed this crime when he paid for the earrings with a check drawn on the trust account and then recorded the check being issued to pay costs of the litigation. Girardi didn't even bother to wash the money by depositing the trust account check in a personal account. He just issued the check directly from the trust account directly to the jeweler. She's like, he didn't even fucking launder the money. He just did it. Because now we know from the state bar, I'm not done. Now we know from the state bar that this had been going on for 40 motherfucking years. So why would he bother laundering the money? At this point, he doesn't give a fuck, in my opinion. Why launder the money? Why launder the money? Why bother? It's been going on for 40 years. Never gotten in trouble. Why not? I'm going to have to do a podcast episode on all of these and summarize them. This is worse. This is worse than I anticipated when I started this today. At least I can just be mad. As the recipient of stolen property, Erika Girardi has neither an equitable nor legal interest in the earrings. Look, this puts the appeals court in a position. I understand why Erika wants the earrings back and wants the cash for the earrings. I understand, legally speaking, why she wants that to happen. Here's from a PR point what I don't understand. The appellate court, and this is the same for Amber Heard as well. The appellate court is now in a position to say, this shit is stolen. You have no standing. You're in possession of stolen property. You are legally obligated to give it the fuck back. So give it back. You don't want the appeals court saying that to you, man. The LA Times is going to have a fucking field day with it. Not only does Erika Girardi lack standing to object to the motion, but when Erika refused to turn over the earrings to the trustee and refused to relinquish the claim of ownership after being advised of her husband's conduct, she violated California Penal Code 496A, refusing to turn over stolen property after demanded to the rightful owner upon learning the property was obtained by theft or fraud, subjecting her to a potential criminal prosecution. Let's see if that ever happens. Her conduct also subjects her to a civil claim for treble damages and constitutes her own act of conversion. Why I don't think a prosecution for this will happen is this. She's acting on advice of counsel. She's acting on advice of counsel. Her lawyer is saying, look, there might be a statute of limitations issue, and you are going to need the money to pay the feds, so we have to fight. If you're Erika Girardi, though, do you just say, this isn't worth the cost? Like, this is not worth the smoke? I don't know. I don't know if she's in a position to say that. There is no statute of limitations or statute of repose that bars the trustee's claim for Ms. Girardi's 2021 conduct. So they're saying the conduct didn't happen in 2007. It happened when she found out. Girardi's argument that the earrings are not property of the estate is unavailing. It's undisputed that the client trust account ledger entries demonstrate that the firm purportedly made $15 million in withdrawals that are described as cost and $7.5 million in withdrawals that are described as fees. The payments were made over several years. One of the cost items is the earrings. They're saying she doesn't own the earrings because they were stolen, so they can't be hers. Therefore, she doesn't have standing. The limitations doesn't bar it because of the discovery and because of the fraud. The reliance is unavailing. Like, that argument doesn't help you, though. And it's, a crime. California Penal Code 496A provides in relevant part every person who buys or receives any property that has been stolen or that has been obtained in a manner constituting theft or extortion, like embezzlement, knowing the property to be stolen or obtained, or who conceals, sells, withholds, or aids in concealing, selling, or withholding any property from the owner, knowing that the property to be so stolen or obtained shall be punished by imprisonment in the county jail for not more than 1 year, or imprisonment pursuant to subdivision H of section 1170. 496 is a criminal statute. It's a misdemeanor criminal statute, but yeah, it's a criminal statute. But it also provides a civil cause of action. Any person who has been injured by a violation of subsection A or B may bring an action for 3 times the amount of the actual damages. That's the treble. They don't say triple damages. Treble. Treble damages, not triple. Why can't they just say triple? Or the trouble with triples? No, treble damages. When you hear treble, it means triple. Why they don't just fucking say it that way, I don't know. To make you spend hundreds of thousands of dollars to go to law school to learn that treble means triple, I suppose. 3 times the amount. So whatever 3x 750K is. The property at issue in this case falls squarely within the section of 496. It is receipt of stolen property. And they're saying the statute of limitations therefore does not apply. And these are the arguendos. Arguendo, she holds them in a constructive trust because of the fraud. We're not going to get to the other arguments because otherwise I will not get to the emails. All right. We're going to get to the emails in this next motion. I'm going to look and see. Oh, there's no picture of the checks here. I will find the pictures of the checks when I talk about this. This is going to have to be a deep dive. It needs to be a deeper dive. Let's see. This is the request for judicial notice. Let's see if they're attached in here. Oh, gosh. This is just a printout. Oh, wait. There's an appendix. The appendix for the request for judicial notice is the printout, and the docket. No, we don't need any of those for today. The response brief. We got to keep it brief. Girardi does not have a legally protectable interest in the earrings and lacks standing to object to the trustees. Oh, this is the updated motion. That's the amended motion. Here's the reply brief. And this should be this is the full reply brief. And then the declaration, which is what we want to get to. So the reply brief from November 15th, 2022, which is why we haven't covered it yet. Most of this stuff is fairly recent. New evidence previously withheld by the trustee warrants an issuance of sanctions and a remand for an evidentiary hearing before the bankruptcy court and this court's sua sponte withdrawal of the reference and conduct of an evidentiary hearing. Summary argument of this reply brief. Erika has owned the earrings for 15 years and has standing. The trustee cannot avoid the applicable statute of limitations. Erika's assertion of due process rights and her refusal to acquiesce immediately. Oh, fuck. This is a long header. Erika's assertion of due process rights and her refusal to acquiesce immediately to the trustee's demand to surrender a marital gift innocently received 15 years ago does not result in criminal or civil liability, nor do they reset the statute of limitations. Big mad. The turnover motion was procedurally an improper vehicle. Erika's appeal is not moot. Let's go to the newly discovered evidence because this gets into the email chain. New evidence previously withheld by the trustee warrants issuance of OSC, order to show cause regarding sanctions, and a remand for an evidentiary hearing before the bankruptcy court. Your Honor, remand it. This court's sua sponte withdrawal of the reference and conduct of an evidentiary hearing. A federal bankruptcy trustee is an arm of the Office of the United States Trustee. Similar to a receiver, the bankruptcy trustee serves as an adjunct to the bankruptcy court. As a result, the trustee owes the highest of fiduciary obligations in carrying out his or her duties, including a duty of candor to the bankruptcy court and all parties in interest to preserve the integrity of the bankruptcy system. Part of this duty of candor is to tell the whole truth as to material facts and not withhold or conceal issue dispositive evidence. In this matter, the bankruptcy court found and commented 3 times during the hearing below that appellant Erika Girardi, a non-attorney who never worked at or directed the finances and handling client matters, was innocent of any wrongdoing at issue that occurred in Girardi case and had no reason to suspect foul play. That's interesting to know. I'm going to read it again because I feel like I read it awkwardly. In this matter, the bankruptcy court found and commented 3 times during the hearing below that appellant Erika Girardi, a non-attorney who never worked at or directed the finances and handling of client matters at Girardi case, was innocent of any of the wrongdoing at issue that occurred at Girardi case and had no reason to suspect any foul play when she received a gift of earrings 15 years ago from her then husband, Tom Girardi. The bankruptcy court, however, relying on representations of fact from the trustee, found that the evidence showed that Girardi, as well as one of his partners, James O'Callahan, had taken funds to which they and Girardi Keese were not entitled out of the client trust account by issuing a check to a jeweler to pay for the earrings that Mr. Girardi gifted to his then wife, Eric, or that Tom gifted to Erika, specifically based on a factual premise that neither Girardi Keese nor Tom Girardi had any legal entitlement or claim to receive the funds at issue. The bankruptcy court found that this conduct constituted embezzlement from day one. Embezzlement is a form of theft. Yep. As the trustee knows, it would not be embezzlement if the funds taken by Tom Girardi or Mr. O'Callahan out of the trust were funds to which GK had a legal entitlement and right to receive as attorney's fees due. And this is where the new argument comes in, that even if the money was taken out of the trust account, it was owed to Tom Girardi and his property. That's the new argument. That's the new argument. In this event, the wrongful conduct of Girardi and GK was of a different nature because they were titled and accounted for the check to the jeweler for costs of litigation, which was false. What? In this event, the wrongful conduct of Tom or Mr. O'Callahan and Girardi Keese was of a different nature because they titled and accounted for the check to the jeweler as for costs of the litigation, which was false. We saw the check. The fact of characterizing a payment as reimbursement of costs as opposed to fees, if the same amount or more was otherwise due as fees, is not a theft from the clients or anyone else. That's the argument. Nerd that knits, I agree with you. How would she know that the money came out of the fund? She wouldn't. I don't think she needs to know that the money came out of the fund. For the money to be embezzled and for it to be a receipt of stolen property, she doesn't need to know. Once she's told, then we've got another issue. They're saying that Tom Girardi is entitled to those funds, therefore the earrings are properly Erika's. Rather, it would appear to be an attempt by Tom or O'Callahan to evade income taxes by describing an otherwise legitimate payment of fees as a cost reimbursement. Your Honor, Your Honor.
Your Honor, my client doesn't need to turn over the earrings. See, and this is why. The earrings for $750,000 really were monies that were taken by Tom Girardi that he was owed, but he didn't want to pay taxes on it. So he labeled it as costs, even though it's really fees. So the real problem is Tom Girardi was evading his taxes, but that's not Erika's fault. Like, let her keep the earrings because really they're fees, and his mischaracterization of them as cost isn't embezzlement, it's tax evasion, Your Honor. But it's not my client's tax evasion. It's her husband's tax evasion. It's the law firm's tax evasion. But it's not embezzlement. The fuck?
God damn it.
I didn't mean to voice change her into the thing. Your Honor, it's not embezzlement. It's tax evasion. And that's not my client's problem today. It's law firm tax evasion. or it's Girardi evading taxes because he didn't want to take it as fees. Either way, it's not Erika's tax evasion. I mean, Tom's tax evasion is going to become Erika's problem because married. Your Honor, it's just tax evasion. Look, y'all, anyone in the chat who's like, I want to be a lawyer. This is lawyering. This is lawyering. These are the arguments you're making for your client because you are ride or die for your client. Rather, it would appear to be an attempt by Tom Girardi, Girardi Keese, and O'Callahan to evade income taxes by describing a legitimate payment for fees due as a cost reimbursement. This is also not how you take costs. This is not how you take fees. For this misconduct, Tom Girardi and Mr. O'Callahan should respond. But it cannot form the basis of any claim by the trustee against Erika. It's not her fault, Your Honor. Tom Girardi's tax evasion's on him, whom the court already found correctly to be an innocent recipient of a spousal gift 15 years ago. The trustee presented to the bankruptcy court as evidence of receipts, distributions, and balances of the resident client trust account, a document titled Case Card Register, which is not an actual bank account statement, but rather a separate ledger created by someone at Girardi Keese with information spanning between 2007 and 2014. The trustee did not present to the court or produce the actual bank account statements of the client trust account at issue. That's interesting. You would think you would want to see the bank statements and see the withdrawals. The trustee's case card registered showed 2 settlement payments at inception from Merrick, January 2007, totaling $65 million. Ooh, here's the tea. Now we're gonna have to do more of this later. We are too deep. We're gonna have to do a whole podcast episode on this because there is so much more. Okay. The trustee's case card register showed 2 payments from Merrick, January 2007, totaling $65 million. The trustee also advised the court that the case card register showed payments of fees of $7.5 million, costs of $15 million, including a check for the earrings, for a total of $22,573,805, footnote 2. At the time of the March 2007 payment by Girardi Keese to the jeweler, the balance of the account, according to the Resilient case card register, was $55,854,302, and only $6 million had been paid to Girardi Keese at the time. It was not until more than 18 months later, in October 2008, that the Resilient case card register began to show a negative balance. Given that the trustee has not produced any of the underlying bank account statements, counsel for Mr. Girardi does not know whether, in fact, the payments reflected in the case card register, including to the Resilient clients, were in fact honored by Girardi Keese's bank, and whether Girardi Keese or Tom Girardi added funds to the actual client trust account to cover those payments. Your Honor, these were fees due. It's not embezzled if he's entitled to it. It's not embezzled if he's entitled to it. So, oh, y'all, I am going to have to wrap more. I am going to have to wrap more quickly. Let's see. All right. Sorry, I was getting weird notifications, but I'm going to have to wrap more quickly. So they're arguing that it's not embezzlement because it was fees owed. I want to dig into these arguments a little bit more. A critical foundational question, factual question, therefore, has always been, did Girardi Keese have the right to receive the fees of $750 that was subject to the check to the jeweler, regardless of how the check was labeled, or did Girardi Keese, by issuing the check, outright misappropriate funds to which it had no entitlement, which would be theft? Understanding the importance of this fact issue, 11 months ago in December 2021, counsel for Erika sent correspondence to the counsel for the trustee stating in pertinent part, quote, I have reviewed the Resilient mass tort case ledger. I can't tell from the ledger the total fees and costs legitimately due to Girardi Keese from what appear to be at least 2 different settlements totaling $65 million. Are you able to provide what you and the trustee can represent to be the best of your knowledge is an exemplar fee agreement between Girardi Keese and its clients? What was the fee agreement and what are they owed? Without this and other info, I can't tell whether A, the $750K paid out of the trust to the jeweler in 2007 represented funds otherwise due to Girardi Keese, in which case the trustee would have standing to recover those funds, but the claim would be barred by the statute of limitations. We don't have to get them back. Or the $750 to the jeweler represented funds that were property of the clients, in which case, irrespective of the statute of limitations analysis, the funds were never property of Girardi Keese, and the trustee would not have standing to sue to recover them. Is it money owed to the client or is it money owed to Girardi? If it's money owed to Girardi, then it's too old, tough luck. If it's money owed to the clients, then you don't have standing, tough luck. That. Counsel for the trustee never responded to the above request, never provided an exemplar of the fee agreement until the evening before the reply brief was due. Disturbingly, the client retainer agreement provided by the trustee provides that if a recovery is obtained after filing of litigation, which is what occurred in this case, the fee is 40% of the gross recovery, after which Girardi Keese would be entitled to costs from the client's share. Fees, costs, clients. It's like the really shitty version of Bears Beats Battlestar Galactica. Fees, cost, clients. In other words, based on the settlement recovery received as shown in the ledger, $65 million, Girardi Keese was entitled to attorney's fees alone prior to the reimbursement of costs of $26 million. This amount exceeds by $3,430,435 the amount of fees and costs paid to Girardi Keese, according to the ledger of $22,574,805. In sum, the belatedly produced exemplar client fee agreement shows that Girardi Keese had an entitlement to fees well in excess of the amount it actually received from the client trust account. In this circumstance, embezzlement would be and is impossible. But the key evidence to support this conclusion was withheld by the trustee. A pox on the trustee is what they are saying. Bad trustee. What the fuck? Why didn't you give this to us sooner? Based on the foregoing facts, including the trustee's belated production of evidence previously intentionally withheld, which completely changes the outcome of this matter and contradicts any finding of embezzlement, Erika will be shortly filing an ex parte application for an order to show cause as to why the fuck you should not be. That's not what it says. As to why the fuck you should not be sanctioned for withholding dispositive evidence for an evidentiary hearing regarding reconsideration of the order granting the trustee's turnover motion. Alternatively, we are determining whether, in light of this unique jurisdictional relationship between district courts and bankruptcy courts, Erika Girardi should file the above OSC before this court, along with a request that this court sua sponte withdraw the reference and conduct an evidentiary hearing for reconsideration of the turnover motion. We're not done yet. We're not done yet is what this is saying. What a mess. Summary of argument for the reply brief. Didn't we just fucking do it? Independent of the issues discussed above, 3 facts are unavoidable. There are 3 truths that are unavoidable. Edward is a vampire. Sorry, no, that's not what's happening. 3 facts are unavoidable for the trustee. First, as found by the bankruptcy court, Ms. Girardi has done nothing wrong. Footnote 3. As stated by the bankruptcy Judge Russell, they're going to put this in every single motion. I understand why. As stated by the bankruptcy Judge Russell, quote, just for the record, from my standpoint, I accept what Erika has said, that given the nature of what I know about the case, to say that it's unlikely that Erika was aware of any of the shenanigans, Your Honor, good use of shenanigans. We appreciate it. To say that it is unlikely that Erika was unaware of any of the shenanigans going on would be an understatement. Quote, I don't believe that Erika knew the diamonds were stolen property. There's no evidence of that. Fair. I think that's fair. It's what happened after. She has not been found guilty, let alone accused of any crime, and is completely innocent of any misconduct. Second, the alleged fraudulent transfer of funds to pay for the earrings as a marital gift innocently received by Erika occurred in 2007, 15 years ago, bringing the trustees' attempt to claw them back well beyond the applicable statute of limitations and statute of repose. For 15 years, Erika has possessed the earrings, understanding that they were a gift from her now estranged husband. The law matters. Yeah. And the California Uniform Fraudulent Transfer Act, as codified, establishes a statute of repose and limitations applicable to all causes. Third, the trustee's theory that the funds used to acquire the earrings were stolen property from the clients and not property of Girardi Keys. The trustee incorrectly argues that the earrings were property of the Girardi Keys estate. We're going to get through the rest of this legal motion in a podcast episode. I wanted to get to the declaration real quick, and then I'm going to have to go. I wanted more time for Q&A, but I'm not going to have time because I've got to go. I've got to go. This is wild. Y'all, we're just here. Miguelina, will we put up a quick poll? Do you guys want a whole deep dive into the appeals surrounding the earrings? I think we need a deep dive into the appeals surrounding the earrings. I'm kind of fascinated, and there's more here. And I think I can do an episode that summarizes this and summarizes the highlights of the arguments and the legal standing of the arguments, because the appellate court is going to have to determine this. But you've got Erika Girardi arguing that Tom is committing tax evasion or possibly committing tax evasion. And I think it warrants a deeper look. So let's put up a poll and take a look. Declaration, and then we'll get through the law of the thing, separate and aside from whether we think Erika should give this shit back, because I think everybody's like, just give it back. But we should get through the law of, but do you have to? And I want to pull up the check, which is going to take me slogging through documents to pull up the check and take a look at the evidence side by side. Do you want me to walk through this and break it down like I'm evaluating this to prosecute a theft? Let me know. Declaration of Evancy Borges. I am an attorney duly licensed. I'm a partner with the law firm. I am the counsel of record for Erika. I have personal knowledge of the facts. In approximately late November 2021, I received a communication from Larry Gabriel, who had substituted in as new counsel for the Girardi Keys bankruptcy trustee, and the trustees about the trustee's interest in potential claims against Girardi for recovery of the earrings, gifted to her in 2007 by Tom. Attached Exhibit 1 is a chain of emails between us from the period of December 10th to December 18th, in which we discussed the issue of Tom's claims related to the earrings. Gabriel started the chain with an email to me with a copy to the trustee, as well as her outside general bankruptcy counsel. Accordingly, the ensuing emails in the chain between us include my email to him of December 18th, 2021, copied both the trustee and outside counsel. I never received a response to my request for an exemplar of the fee agreement. After we exchanged formal written discovery, which is outstanding, earlier this month on November 6th, I sent an email asking to expedite the production of the client agreement. The ensuing email chain through November 14th is attached as Exhibit 2. Attached as Exhibit 3 is a true and correct copy of an email plus attachment, which I received the evening of November 14th, the day before the reply brief was due on November 15th. They then got an extension, and I believe. No, this was filed November 15th, so maybe not. The attachment to the email includes an exemplar of the fee agreement. I have never seen this exemplar of a fee agreement before, and it had never previously been disclosed to me. And so then we get all of the emails. There is one we are going to go through at the end. I will go through the rest of these, I think in a podcast episode. I wanted to back up to the fee agreement real quick. So the fee agreement was turned over, and this is what was provided to them. Remember, there should be 1,000 of these on file somewhere because there's 1,000 clients. Compensation of said attorneys will be on a contingent fee. Said attorneys shall receive 33 1/3% of all gross monies recovered prior to litigation. Once an action is filed, whether completed by settlement or judgment, attorneys shall receive 40% of all gross money received. Then the costs come out. I authorize the attorneys to advance costs and expenses in handling the matter. I agree that such costs and expenses shall be reimbursed to said attorneys out of my share of any settlement monies obtained or any monies obtained by the way of judgment. I authorize the attorneys to employ, and then they list all the people they can employ. I agree to give the attorneys a lien on my cause of action or any judgment, settlement obtained thereon to the extent the above listed fees, percentages, and to the extent of all costs expensed and expenses advanced on my behalf. If there is no recovery made, no charge will be made for legal services. And that is how they get away with the 40% fees. Let's look at the email leading. This was a can you get it to me? Like, these emails are all can you get it to me emails. ETA. warning. I need this. Can you please get it to me? But I was this is a response regarding a protective order from December 10th, 2021. This is from Larry to Evan. It's my understanding that Evan is responding in blue to the emails, and that is the chain we're looking at here. But let's see. Thanks for the email, Larry. See my responses typed in blue. By the way, what's with the small font? I'm old and require a bigger font. Something I would say. Why the fuck is your font so small on your email? Larry or Evan. So Borges's response is in blue. I'm reviewing the draft protective order that you proposed. Also, you can make documents bigger, but I agree. It is a small font. I am reviewing the draft protective order that you proposed. As we discussed, EJ Global status has been suspended by the Secretary of State for failure to pay franchise fees. Here's the answer from Evan, Erika's attorney. Regarding the suspension of EJ Global LLC, first, I was unaware of it until you recently advised. Second, I will be fixing it soon so EJ Global is in good standing. The corporation was not in good standing, so they can't defend this action. Second, I will be fixing it so that EJ Global is in good standing. Third, as an FYI, I'm informed the suspension was not due to a failure to pay taxes, but due to a failure to file a statement of information. Literally happens in California all the time. Regardless of the reason, I will get this fixed ASAP, meaning next week. Please stay tuned. As to the stipulated protective order, let's hold off until I get the EJ Global status issue resolved. And then this is back to the attorney for the trustee. As such, EJ Global is precluded from defending this action. You advise that you are going to look into the issue, and I assume get the fees paid. Also, I would appreciate it if you look into and provide an explanation for a transaction that occurred in 2015 where it appears that Walter Lack gave Tom Girardi $2.5 million that Girardi then may have used to purchase an interest in a casino referred to as the Bike. I wonder if this is the Bicycle Casino in California. And that Girardi was going to put title in the investment in the name of Erika. I have so many questions because Walter Lack is the one that is said to have also been giving money to Erika for attorney's fees and things. I want to know if Erika has an ownership interest in a casino. I have not yet discussed with my client, but will do so. I expect to get you whatever information we can gather on this within the next week. I have questions. From the trustee. Finally, we need to formalize your acknowledgement that Erika has possession of a lot of jewelry, including the $750,000 earrings, and that she will retain possession of the jewelry pending resolution of the litigation. Yes, it's correct that I told you EG has a lot of jewelry. It's a lot. Which I was informed she showed to a jeweler representative of the trustee some time ago and prior to my involvement in the case. To be clear, I have not yet asked Erika about the $750K earrings referred to in your correspondence, which attached a check payable to a jeweler dated March 2007, more than 13 years ago. Thus, as I write this, I don't know if Erika ever received the earrings, which I note as a possibility not to be a jerk. Fair enough, Evan. But due to the Tom Girardi marital infidelity issues, this is a fair lawyer argument. Fair. I don't know if Erika got the earrings. Tom was just throwing it around, the money. And I don't know if Erika has the earrings in her possession. Well, we saw her wearing them on a Real Housewives, so now we know. But I will find out. As to all of Erika Girardi's jewelry obtained or received during her marriage, to Tom Girardi, my intent is to provide you a specific inventory and representation from Erika that nothing will be sold, transferred, or disposed of, which is fair, until we resolve any and all actual or potential claims of the GK trustee or the TG trustee. That's fair. Look, we're not going to sell or do any of the rest of it. We're not going to do that. That's fair. Notwithstanding, this is back to the trustee's lawyer, notwithstanding, I have concerns that another creditor may take some action that will somehow prejudice the trustee's right vis-a-vis the jewelry, but more specifically, the diamond earrings, which we have indicated must be turned over to the trustee. Let's discuss on Monday how we can address the issue without the need for a lot of law in motion. Back to Erika's attorney. Yes, glad to discuss further on Monday regarding the merits of the GK's trustee claim to the earrings, as asserted in your recent letter. As I mentioned during our prior meet and confer discussion as part of our continuing Rule 26 discussions, we are looking at the statute of limitations issues given that the trustee's claim is based on a transfer of funds to buy an asset of jewelry that occurred more than 13 years before the filings. The transaction was known to GK at the time, given that the check you attached was signed by Tom Girardi and another partner of the firm. My associate has done a statute of limitations research as to the trustee's claims to the earrings. For settlement purposes only, I am glad to provide you with Jack's research. From a common sense standpoint, my questions would be whether Girardi Keese's trustee rights would be any different if the transaction took place 35 years as opposed to 13 years before the filing. And then, did you listen to the hearing in Chicago yesterday? Unreal on many levels. The attorneys want to have a chit chat about the contempt hearings in Chicago that I was listening into too, that we just talked about, in the interview with Edelson PC. So now in the emails, we have the attorneys being like, but did you see the contempt hearings? Because let's talk about those. Did you listen to the hearing in Chicago yesterday? Me, to all of my friends, when I called them after those hearings, going, oh my God, you're not going to believe what happened in these contempt hearings. Unreal on many levels. From Evan, I didn't listen to the hearing, but I have read several media reports. Mr. Evan C. Borges, you missed out. I'm not surprised if Edelson, as co-counsel to clients, was aware of a violation of a court order by his fellow co-counsel. Edelson has a duty to report. Not in California, but yes, in Illinois. Also, my understanding is that in Illinois, the ethical rules place an affirmative obligation on an attorney to report ethical breaches by another attorney. That's true. Attorney acquaintances of mine who do a lot of legal malpractice defense have mentioned to me that Edelson has real liability risk that could be on the hook to the clients for what Tom Girardi did. And Edelson has paid the clients. I'm not defending Tom Girardi's actions at all, but a point seemingly lost on Edelson is that attorneys who worked with Tom Girardi on cases, not only at Girardi Keese, but as co-counsel, are held to very high standards. Well, Tom Girardi never was. This is one of many reasons why it bothers me that Edelson is dumped on Erika Girardi. I appreciate that he said dunked on and not dunked on, but okay. This is why this is one of the many reasons why it bothers me that Edelson has dumped on Erika Girardi as a non-attorney who certainly didn't manage the firm or anything related to Lion Air. The fact remains that all Erika Girardi has to her name is her personal possessions, yes, including jewelry, and her housewife's income. And her divorce filing was and is legit. As Erika said, she's like some jerk in Illinois saying it was a sham. I did get the media's attention, though. As it appears, the GK attorneys testified at the hearing, Tom Girardi was not the most approachable or responsive person when it came to asking him tough questions. That seems to be an understatement. And that's the end of the emails. We will dive into these more. Unfortunately, I do have to go. The rare time something should indeed not have been an email. Yeah, this is a phone call. But sometimes attorneys don't expect that their emails are then going to be in court filings, but now the emails are in court filings. Is this the equivalent of being caught talking shit about your colleagues? Not about your colleagues, because they're not at the same firm. These are not colleagues. They're in opposition. Erika's in opposition. Erika's being sued by Edelson PC. So this is talking shit about opposing counsel, which is literally the thing that keeps the law going round and around. I'm going to swoop through, and then I have to go because I have to zhuzh my hair before I have another interview. So So, did Erica have the $750,000 earrings on the show? Yes. I thought she was wearing a different pair. No. We're gonna end the poll and see what you guys want to see. For sure. Do you want a deep dive surrounding Erica's earrings? Yes, 75%. The law nerds have spoken. Look, there's over 6,000 of you here. The law nerds have spoken. Smack talking the other sorority or something, kind of. And it wasn't horrific smack talking, but it was a little bit of like, ooh, girl, you in danger. Edelson PC, you in danger. They weren't the only ones saying it. Others were saying, what's Edelson's responsibility? What I appreciate about Jay Edelson is when questioned by the court about that, he said, and we might be. And so be it. If the court finds us too, so be it. This is why we didn't tell the court sooner. We're flabbergasted. So, are they charging their clients for this little chit chat? It depends on the way their fees are structured. But yes, attorneys generally charge for emails. I think they should stop doing so. But it depends. Because most of this is back and forth about work. So if you guys have not done the poll yet over on the YouTubes, if you go to the community tab on my channel, poll number 3 is up, narrowing down the final 4. It looks like food court is winning. So if you guys want to vote on food court or food fights, we will get down to 4 potential names for our food segment, and I will put up a poll to do that. Food court, served is one of them. Sous chef, SUE, and there's one other one that is escaping me off the top of my head, but we will put up the 4. Oh, it's the culinary court. So I will put up those 4 to see what our segment is going to be named. If I did not get to your super chat, I apologize. It is a busy day, and I do have to scoot so that my hair, I mean, this is the hard thing about having to get the hair done. Mallory is like, trying to work here and you're cracking me up. Here goes more typos. Thank you for the super chat. I literally picked up my settlement check yesterday. With my check, I received an itemized list of costs. My attorney waived his fees and was given a photocopy of the original check. Dawn, which is appropriate, which is what should have happened. Samantha F. Question, did you ever want to be a federal attorney? I'm blanking on the official name. I did work with the U.S. Attorney's Office. I wanted to start at the district attorney's office. If I had stayed at the DA's office, might I have moved over to the feds because it's a slower pace and you have less cases to manage? Possibly. Am I much happier doing this? Yes. Yes, I am. So, thank you for the question, but I am here. Melly said, my husband was my divorce lawyer from my ex, but we were friends for years. First marriage came years after. Nothing shady. It's not shady at all. Sometimes it's just funny. Someday somebody's going to say that about Law and Lumber. No, I'm teasing Law and Lumber. They're going to say, we met in the chat. Also teasing. It's none of my business. I'm only 56, but social media has grown beyond what I understand, which is fair. I remember when Pong and Pac-Man came out, I learned basic programming, but my phone updates and I hand it to my 26-year-old son, which is fair. Technology does move. Lewis said, Emily G. Baker, you're awesome. Keep being awesome. Also love the hair. Thank you. We've got to go zhuzh it for TV in just a minute because that's just reality and I need to zhuzh a little bit. And knowing myself, I have often been at the ire of my parents due to my forgetfulness. Only after you, Ian, and Rob talk about your experiences with ADHD did I think that may be an option. It's fair, and I'm glad to help people kind of know themselves better if I can share my experiences with you, so you don't have to make the mistakes I did. It's like a cheat code. I made these mistakes. Maybe you don't have to. Watched Amber Heard appeal in replay and was mentally yelling. She said she didn't need to seek medical treatment. She also said she wasn't afraid of him. Love you and being a law nerd. Check out the Disney Starbucks cups. I have one Disney World Starbucks cup. I am going to Disney World with my kids the first time that they will be going to Disney World, and I will be looking for more cups. I will keep you posted on that stuff. So with all of that, y'all, I'm sorry that I have to bounce. So I'm sorry. Rob, is Friday night to be determined or a go? I don't know if Rob is still in the chat. I was on last Friday. This Friday, I am going to be off and away. God, that's tomorrow. I'm going to be off and away in the cold. So I will be off and away, but it's going to be a busy weekend. I hope you all have a good weekend. I will be around the interwebs, Instagram, maybe Twitter. I took Twitter off my phone. It's actually been quite nice, but now I feel like I'm missing things. So I'm dealing with my own internal FOMO, but I will be around the interwebs on the Instagrams. This weekend, I will be back here on Tuesday. I think I'm going to do a bit more of a concise deep dive, not a first look on this case, and break down the timeline of this appeal, because this appeal is heating up and the arguments are interesting. So far, the arguments are that shit's not yours, that shit's not yours, tax evasion, and statute of limitations. What? So we're gonna have to go. I think we just have to go through it, don't you? Oh, I need to put my switch back in my background. We need to just go through it. What else is there? I mean, that's really everything. So I will be back on Tuesday. We need to do a Brittany deep dive. It's on my list. We need to do a case roundup. It's on my list. I'm sorry if I didn't get to super chats. Now I'm repeating myself. I have to self-yeet. I will let you know when what I am filming today will be on your televisions and where to find it. I will keep you posted around social. Final updates. 1, the text crew, we are looking at moving providers. If you're in the text crew, I will keep you up to date. If you're not yet in the text crew, maybe just wait a minute so you don't get swooped into us switching providers. I will put more information out on the community tab here on YouTube and in our members spaces. If you are in the text crew and no longer wish to be in the text crew, it is always fair to say, hey, I don't need updates right now, and you can yeet just by texting stop if it is not for you. I also update on Patreon. If you're like, I'm international, I don't want to be in the text crew, but Patreon will send you updates when I post things so you can see it. Even if you're not a paying member, you can follow my Patreon and get those updates of when I'm going live. I put those in there. So with that, I've got to go. Thank you for being here. Thank you for being law nerds. Thank you to our moderators. As always, they are amazing. Have a great weekend, y'all. I'll see you back on Tuesday. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.